By the commercial court in passing an interlocutory order pending decision in the suit. Appeal fails, same is accordingly dismissed.
Much obliged. Well, my lords may permit me. Serial number 8, my lords. I appear for the appellants. There are settlement negotiations going on, my lords. It's likely to be settled.
Occupancy certificate matter.
My lords?
Occupancy certificate matter.
Yes, my lords.
Yes, when do you want it?
2 weeks' time may be granted.
It is submitted by the council for the appellant that settlement negotiations are ongoing. List after 2 weeks.
Yes.
You've informed the other side.
Yes, my lords. Obliged.
Process against R1 to R3 held, no, they've appeared. Yes.
Page 4, 24. Page 5, 25 to 31. Page 6, 32 to 34.
Serial number 35, who's that, Mr. Worship?
Yes.
So I have submitted some return state arguments with some schemes. There are certain schemes are there. And I have informed the other side, he's online. Your Worship.
I have no objection.
After 15.
I have no objection.
Yes.
After 15 years.
Obliged.
RTMI. Let's see, serial number 40. I am for appellant, my lord. I informed the other side also. 1 week time may be granted.
Yes.
Okay.
Serial number 45, my lords. For the appellant in this matter, respondent counsels are present. R1 has gone to CIRP in this matter, but there's an appeal pending in NCLAT. It may be adjourned to await what happens in NCLAT, my lord. By
My lords, I appear for R2 because my lords, R1 is now under the CIRP process and a moratorium is imposed. I only appear for R2, my lords.
Can be.
My lords, I'm ready to extend the undertaking.
please,
Only in respect of R2, my lord, that may be recorded in the order because my lords, otherwise the NCLAT.
because the NCLAT is for appearance for orders today, my lord. So we maybe see what happens through the moratorium. Maybe listed after 4 weeks or so.
Appellant seeks a week's time. List after a week. The undertaking given by the second respondent
Please, my
shall remain in force. till such
Maybe because it's listed for orders made continue on behalf of R1 as well until the next date of hearing, just to only to protect my interest, my lords, because as per reports, it seems like it's going to be settled with with their operational creditor. If it goes, then I don't want to be.
Is an undertaking.
Please, my
Who
lords.
appears for R1?
R1, it's supposed to be the IRP. He's not present, my lords. Then, my lords,
Therefore, let's leave it like this. Let's have it next week.
please.
A week after,
Likely that anything is going to.
week after that.
On behalf of R1 also.
Lords, I don't want to take that risk because what R1 is doing. In that case, my lords, maybe it may be taken up on at the course in the course, my lords. I'll just make
Yes.
appropriate. Grateful.
3 p.m. 2:30 p.m.
Yes, don't do anything.
It's appellant in this matter, my lords. My lord, basically, we are appealing an IA passed by the lower court.
Against non-grant of temporary injunction.
Yes, my lord. For permanent injunction, we are seeking for. The respondent has a.
Grant of temporary injunction is what you have filed the.
Yes, my lord. Yes.
Yes.
my lord. Yes. So, my lords, may have the impugned order.
Mm.
The impugned order is from page 25 onwards, annexure A. Now, my lords says page 25. The plaintiff, I'm just referring to the name of the plaintiff. My lords can see Major Gandhi Kote Ramanna Nagabhushana. That is the name of the plaintiff, and bracket you all written proprietor of Ashwini Electronics. Now the issue here is, my lord, what has happened before the trial court, when we made an agreement, when we transfer 1.5 crores for the agreement, 1 crore was made from his personal account, from this company account, which is Ashwini Electronics. And
What's Impact Solutions Group?
yes, my lord. Yes, my lord. So I'll just read these 3 pages from the impugned order, my lord. Before that, page number 51. Just 3 pages, my lordships may have.
Mm.
Just 2-3 paragraphs.
Mm.
One is page 51. There is para number 44.
Mm.
It says, on the perusal of the copy of the bank account statement produced by the plaintiff, prima facie, it shows that the said bank account was standing in the name of the plaintiff. But the last line of the same para, it says, but on perusal of the said documents, prima facie, it shows that those documents are not much helpful to the plaintiff.
At present, to decide the present application, those documents are not much help.
Not helpful. So further reasoning is given from page 54 onwards. Let's have page 54, para 47.
First of all, the defendants have produced email dated 29/11/16. Email was sent by one Nagabhushna to defend number 2. The defendants have produced copy of legal notice.
So-
One Messrs Impact Solutions Group.
Yes, I'll clarify that, my lord. Just 2-3 paragraphs will just show your lordship.
Hmm.
Para 47.
Hmm.
Now I'll just read this para, my lord. Further it is contention of the plaintiff. I'm the plaintiff. Contention of the plaintiff that as per the terms and conditions of the PMOU and LOI, that is a MOU and a letter of intent, the defendant number 1 company's board of directors was supposed to conduct a due diligence in respect of the petition schedule and issue a formal approval for sale of the property by providing shareholders approval and authorizing the defendant number 2 to sell the scheduled property. So basically, my lord, this land is in the name of the company. So we made an MOU with the director who was said he represented the company, and we gave 1.5 crores, 1.55 crores to be precise, to the company. Now afterwards, he's supposed to get us the shareholders approval and board resolution, which he fails to do. Therefore, after a couple of years of lapse, we have filed just a money recovery suit asking him to return the money. That is our case. In the money recovery suit, we have filed an IA order 39(1) and 2 asking for not to alienate this property during the pendency of the suit. So now the issue is the reasoning given for not giving the injunction order, para 49, my lords. If I may read from 49 and 50, these two are enough, I believe.
Yes.
As stated above, the contention of the defendant is that at no point of time, the alleged transaction shown in the plaint has taken place between the plaintiff and defendant. So they're saying no transaction has taken place between the parties. And also, as per the version of the plaintiff itself, it shows that the alleged transaction was taken place between the defendant and one impact solution group. And as such, as per the alleged MOU and LOI, the plaintiff has not got any right over the petition scheduled property. So everywhere the reason being is they're showing the MOU, my lord. I'll just take your lordships to the MOU, which is at page 108. So what happens, my lord, when the MOU is done, it is in akin to an agreement of sale, because it's a company transaction. They don't get it registered. They do an MOU. Later, they decide that we'll do a registered sale deed. So in the MOU, the plaintiff, my lordships, have page 108, which is the MOU. Page 108, preliminary memorandum of understanding. So it's again a preliminary MOU, to be frank. So the parties are being introduced, my lord. The first paragraph, my lordships, Mrs. Impact Solution Group. Now, in the last line, if my lordships may see, represented by its chairman and managing director, Major G.R. Nagabhushana, who is the plaintiff. So, my lord, what is the issue here is Impact Solution Group. No such entity existed when this agreement was entered into. Because the plaintiff, his intention was, let us make an agreement for sale. He had floated 2 to 3 companies, and when the land was supposed to be executed by way of a sale deed, then he would have got some investor in the company, and then ultimately he would have taken in the name of the company. But since the transaction never went forward, since the absolute sale deed never happened, he had no requirement to form any such entity or do such transaction. Therefore, my lord, if the same MOU, if my lordships may see, page 109, the next page, page 109, bottom but first para, I'll just like to read, my lord. Bottom first, before that one para, where it starts on both the parties. My lord, it says, both the parties affirm that they shall implement this merger and acquisition transaction because it was the company acquiring a company's land. Both shall implement this M&A transaction in good faith and shall take all necessary steps to see that the M&A successfully go through expeditiously. Now, the relevant portion is this, my lord. In the event the company M&A model is not feasible, both the parties have mutually agreed to opt for a sale/purchase of the real estate asset only. That means if the company-to-company transaction is not happening for any reason, like a real estate transaction, individually, I will buy the land. That is also there.
Memorandum of understanding shall be valid up to the 30th of September 2015, and both the parties hereto shall be free thereafter from their obligations herein written if the progress achieved until then is not found satisfactory by either of them.
Yes, yes, my lord. So for the purpose of limitation, my lord, actually there were two suits. When after we entered in this MOU, we realized that the matter was pending before the Karnataka Appellate Tribunal with respect to the title itself, there was a dispute. So that suit got over way back in 2016 or 17. And after that, one more person filed a suit in 2018 before the Anekal court claiming that it is his property. Again, in which plaintiff was also defendant number 2. So all those disputes got over in 2013 itself. So since all the pending litigations were there in the matter, that was kept aside. So after
Request kindly pass over, my lord.
Caveator,
I am for the caveator, my senior held up in first court, man. Kindly pass over.
please file your objections. We'll have it
Please, man, we will file objections.
My lord,
Wednesday.
Please, man.
well, on the last 3 occasions, they have sought time to file
No, no,
objection. Till
no.
now, they have not filed.
Yes,
As a,
we see that it is.
No,
filed.
then next, finally, my lord.
Yes, it is submitted by the learned counsel appearing for the caveator respondent that objections will be placed on record by the next date of hearing, listed on Wednesday.
obligation.
Thank-
Appellant.
So the caveat of respondent.
That appellant is not a non-banking finance company
Yes,
from whom defendant number 3, respondent number 3 before my lords had sought some financial arrangements. But in one of the transactions between the two of them, that there is a letter of intent, a request for settlement because the loan amount gets not defaulted. Defendant number 3, that is respondent number 3 before my lords, and defendant number 1, that is appellant before my lords, enter into some kind of a negotiation for, there is a request for proposal for OTS from respondent number 3, defendant number 3 to the appellant, by virtue of which sum of rupees 2 crores 85 lakhs, which is due as on that date, is sought to be reduced to 90 lakhs. But 54 lakhs to be paid in the first installment, and a little over 15 days thereafter, another 36 lakhs is to be paid. Totally 90 lakhs is to be paid. 15 days after payment of the first installment, RTO documents in relation to the 2 buses have to be released by the appellant. That was the terms of the letter of intent. Letter of intent not binding, as your lordship survey, unless the terms are fulfilled. But immediately after that letter of intent is issued, an amount of rupees 61,56,000 comes to my account, the appellant's account. Appellant, my lord, again I would respectfully reiterate, that is a non-banking finance company who lends money, my lord, and for its transactions. But 61,56,000 comes to its account. Within 15 days thereafter, the defendant number 3 does not come to receive the RTO documents. RTO documents of the buses belonging to the defendant number 3. Now, till that time, lord, the respondent number 1, that is the plaintiff before my lords, is not in the picture at all. Thereafter, my lord, the next installment of 36 lakhs, there is a default. So, my lord, as per the letter of intent itself, I am entitled to retain the amount towards the loan transaction. I have retained the amount towards loan transaction. Thereafter, there is no, my lord, the defendant number 3 is not in, again, not to be
the
traced.
intent is between you and D3,
There is, yes, ma'am.
not.
No, absolutely no transaction. There is no privity of contract. Throughout, my lord, my case has been that there is no privity.
But 61.56 lakhs is paid by the plaintiff.
Lord, I come to know subsequently, he does not, Lord, ask me whether I can remit this amount to your account. He does not, Lord, there is no communication whatsoever between me and the plaintiff till the time I receive legal notice from the plaintiff. And I'm sorry, just before that, there is a request for the RTO documents from the plaintiff. I say, my lord, let the owner come, I'll give it to hand over the RTO documents to the owner. That is all that is the only communication.
No agreement,
No privity of
understanding between you.
absolutely nothing. But in the first instance, my lord, there is an ex parte judgment and decree. I have not entered appearance, my lord. There is an ex parte judgment and decree. Thereafter, I file a miscellaneous application before the same court. That is also dismissed. Thereafter, I approach this honorable court. This honorable court, my lord, with a clear finding, returns, my lord, remands the matter back to the suit, saying that prima facie there appears to be no privity of contract. But in spite of it, my lord, after my lord, evidence and everything, the commercial court comes to the conclusion that I have to return, Lord, the entire amount of 61 lakh along with interest. And that is the finding. Lord, I am agreed by that and I have approached this honorable court with this appeal. There is absolutely no finding about the privity of contract, except not for a passing reference that the amount has come to me from the plaintiff.
Lords, in- Lords, insofar as the respondent is concerned, I agree with everything that my learned senior mentioned. Till the time that the RTO request for RTO documents was made, there was no communication between the plaintiff and them, the appellant before this court. So what has happened is the entire amount of 61 lakhs and change has been deposited into their account directly. There is no reference to the fact that it is being paid on behalf of defendant number 3 at any point of time before that.
Correct.
Once they have allocated that money into the defendant number 3's account without any instructions, then when I go request for the RTO documents, they say that, no, I don't know who you are. You please ask the borrower to come and take these documents.
Yes.
So that is the reason
That
the court,
appears to be what the commercial code thinks also. If there's no privity of contract between you.
they should not have
return
received the money as well. They can't take the benefit of one and not give me the benefit of
Kindly-
the other. That is all my argument has been.
Keep the amount in deposit, we'll consider.
What?
Keep the amount in deposit, we'll consider.
If
Keep the entire amount in deposit, we will consider. Here,
which amount?
the entire
61
amount
lakhs.
that has been now, decree amount must be in deposit here. We'll consider the question. It is a first appeal, it has to be considered.
Very well, not. I will not, for the present, not, I will not press for the interim relief. Would your lordship consider,
Yes.
not, early disposal as and when?
Learned,
No, that is the
Keeping
reason.
open.
The reason is because I have not filed an execution. If I file the execution, they'll interim immediately press for a stay.
hold
Yeah.
it.
I will
Keeping-
file my execution. I have no difficulties.
But keeping open,
Yes.
not, the IA for stay, not, your lordship may kindly
Yes.
consider, not, I'll
Yes.
place all the documents, the entire paper book I'll prepare and submit, not that.
First respondent appears,
I appear for the first respondent.
you're for.
I am for the first respondent.
Yes, so and so appears for the first respondent. The other respondents have to be put
Have
on
been,
notice.
have remained ex parte before the court below.
Yes. Should notice be issued? Should notice be issued? Remained ex parte in the court below. Yes. Should it be dispensed or?
Yes, ma'am, they can be dispensed.
Yes, the learned counsel for the appellant submits that R2 and 3 have remained ex parte in the court below. And that the suit was and that the first respondent is a plaintiff. And the notice to respondents is therefore dispensed with, all for the records. The application. IA is, if nothing is stated, you can move the IA.
Yes, ma'am. Your lordship could reserve that liberty, not keeping open the stay, application for stay.
Since no execution petition has been filed by the respondent herein, the IA for stay is left open, is kept open.
Great.
I may be permitted to file my objections to the.
The respondent is free to file objections to the same.
Please.
Yes.
Pass over the matter, that's some difficult. 2:30.
We have it on some other day then.
No, let's now.
Installation of elevators, section 8 dismissed.
Section 8 has been
Because
dismissed.
only in the offer letter, not in the agreement.
That is
Your
what, my
contention.
lords, is the trial court's findings. The trial court says, my lords, the arbitration clause, my lords, has been recognized in the offer. But the trial court says the arbitration clause, the subsequent contract, my lords, has superseded the offer.
In the agreement, there is no clause.
That is what, my lords, is the trial court's findings. I may be permitted to demonstrate, my lords. Now, the question, what remains here is, when there is an arbitration clause and when there is a dispute between the parties which is arbitrable, lords,
That would be the only question to be considered.
yes, please.
We'll have it on some other day. so that
That's
we can-
only difficulty, my lords. Monday, the matter is coming up before the honorable trial court. So till my lords, the next date, if
Monday, nothing
Lords,
happens, we
it
can
is-
hear it.
Monday, it can be heard, my lords. I have no difficulty. Monday.
Cannot be heard on Monday. If Monday nothing happens, we can give you a listing sometime next week and hear the matter.
Let the trial court, my lords, not insist me to, my lords, proceed with the matter, administrative. That's all is my,
On Monday. Yes, the learned counsel for the appellant seeks time and submits that the matter is coming up for the commercial court on Monday. List for further arguments on 12/8. The matter will not be precipitated before the commercial court till then.
much
Grateful,
of.
my lords. On that date, let them
Can-
argue, my lords.
Please,
because-
it must be argued on that day.
Yes, please, my lords. I'm actually ready, my lords. Some personal difficulty, that's all.
Grateful, my lords.
Appeal by defendant.
The commercial suit,
Electrical
filed-
contract. Electrical contract.
please. There is recovery of 1,35,18,513. But the court is decreed for 23,92,851. Because of that reason, appeal is preferred. Your Lordship, what happened? On 14/1/2011, the first contract was given for a sum of rupees 1,45,00,000.
Yes,
And out of which 45,000 was paid. 45 lakhs.
45 lakhs.
45 lakhs.
Hmm.
Then subsequently, the 55 lakhs was given to the vendors. That at that time, there was a technical error. Because of that reason, the defendants themselves have asked me to stop the work. Then your Lordship they stopped the work and he has raised the bill of 45 lakhs. Then thereafter, your Lordship will see, on 17/12/2015, one more work order was given. At that time, there was a contract between both the parties that he cannot claim these 45 lakhs earlier that the balance amount. And he'll give a fresh work order. Then he issued a work order for 1,17,52,856. Then subsequently, pro forma invoice was also given on 17/11/2018 for 2,11,37,394. Work was done, satisfactory work was done. Then out of which 76,18,881 was paid. Then remaining amount was 1,35,18,503 was not paid. Because of that reason, this suit is filed. Then their defense is, your Lordship can see, they have worked for a sum of rupees 91,06,813 and they have paid 87,44,543. Only remaining balance is 4,23,370. And your Lordship is due to the deficient work. They have engaged one more third contractor and work was done by him and he paid 4 lakhs in the amount. And also he claimed for a counter claim. For that 45 lakhs he claimed. The court comes to the conclusion there is no deficiency work. But your Lordship can say court has comes to the conclusion that he raised even the earlier bill that was not raised. Earlier bill was due for rupees 45 lakhs. That was not raised. The court comes to the conclusion that that was also raised.
Just
That is
a
the wrong
moment.
conclusion.
Where is the finding that there is no deficiency? of-
Findings at last, paragraph 5, page 52 onwards. Para 25
Hmm.
and para 27, my lord. May I read, my lord?
Yes,
It is noted that the first work order which was issued to the partnership concerned was for a value of rupees 1,45,00,000, out of which 45 lakhs was paid as a mobilization advance, as noted in the work order, exhibit P2 itself, and there is no dispute in respect of the same since same is also admitted in the plaintiff at paragraph 4. In the cross-examination of DWN, it has been suggested that paragraph 2, apart from the said advance, 45 lakhs, rupees 55 lakhs paid to the vendors directly as ad hoc payment, and therefore the balance amount payable under the first purchase order is rupees 45 lakhs. In fact, the payment of rupees 55 lakhs directly to the vendors is also forthcoming from the letters at exhibit D3, D4. Since under exhibit D3, the said proprietorship concern has requested the defendant number 1 to make payment of rupees 50 lakhs to the vendors directly under exhibit D4, acknowledge advance received rupees 1 crore. mobilization advance 55 lakhs is paid to the vendors. Therefore, from the suggestions put to DW1, it is clear that firstly, suit claim includes claim for payment in respect of work carried out under both work orders. It is work orders. It is not true to suggest that in respect of work carried out as per the purchase orders and also in respect of the additional work, we are liable to pay totally 2 crores 11 lakhs 37,394. Secondly, out of the amount claimed in the final bill at Exhibit P9, which is the subject matter of the present suit, rupees 45 lakhs pertain to the work done under the first work order. This was not claimed. Because even in spite of that, your lordship, if the court comes to the conclusion, the previous work order, that amount was claimed. Then your lordship can see para 27. Anyhow, even as per the case of the plaintiff as suggested to DW1, said rupees 45 lakhs pertain to first order, and even considering the said amount has not yet been paid by defendant, said amount 45 is not payable to the plaintiff, but it is payable to sister concern of plaintiff, which is not a party in present suit and therefore cannot claim the same. We have not claimed that all. Even in by plain, my lord, we have not claimed that 45 lakhs. We claimed only work done under the second contract only.
Should notice to the respondent. But there's no execution filed as yet.
No.
Issue notice, emergent notice to the respondents. The idea for stay is left open.
No, I am. No interview. Please.
The IA is left open. You can move it when required. There's no IA.
No, I am.
Yes. Right.
Respondent, my lord. I seek for a 2 days accommodation for filing objection to the interlocutory application.
With respect, my lord, the last date also they have sought.
No. Yesterday I have filed the, I have
Defendant
entered appearance.
Is an NCLT?
Please, my lord.
Defendant is an NCLT in
Please,
this
my lord.
matter?
The contention here, my lord, this is an application challenged under Order 38 Rule 5, my lord. Now pursuant to the order, my lord, they have also filed an petition before voluntary liquidation. My specific contention that this is a case of siphoning of funds. They have not even informed the plaintiff here that the company is being shut. While admitting that there is a, by way of balance confirmation that the amount is due, they have gone and filed the petition there, my lord. In fact, in their statement of objections to my IA, they have categorically admitted that pursuant to the interim order, ex parte interim order being passed, 5 sites have been sold. Now my contention, and pursuant to that, my lord, the trial court overlooks this particular point and dismisses my IA. Being aggrieved by that order, my lord, I will come before this court.
I need 2 days, my lord. I will
Security
explain.
may be furnished at least till then, my lord, because
2 days I am.
I am in a situation where
I will file my objection. I will explain, my lord.
My brother raises a question with regard to the maintainability.
my lord, on the previous hearing, my lord, there was a maintainability issue whether it will be before the commercial court, commercial appeal or a writ appeal, my lord. The under Order 43, my lord, it is an order passed under Order 35 Rule 6, where upon parties being heard, if an order is being passed, my lord, then it comes
Not under
before.
Rule
It is
5.
not. It's not under Rule 5. The application is under Rule 5. However, the order is passed under Rule 6. Hence, my lord, the petition is maintained.
Yes, this is after 2 days.
2 weeks. Request for 2 days. They sought.
2 days
Please, they sought for 2 days.
12th.
at the request of the learned counsel for the respondent for objections.
Lord, I pray for 3 weeks' time in this matter, my lord.
Library supervisors,
My lord, minimum wages act
minimum wages
to the
library supervisor.
library superintendent,
Under
my lord.
the
Under the minimum
Gram Panchayats.
Gram Panchayats, they had been appointed, my lord. The notification was withdrawn, challenging which the writ petition was filed and an order was passed. Now presently another notification has been already been passed in 2023, My lords, may kindly grant me 2 weeks' time. I shall get ready on the merits of the matter and make my submissions, my lord.
My lords, I'm appearing for the respondent caveat. The very same notification is already submitted by me on 17 January 2024, wherein they admitted the order of they agreed the order of the learned single judge, and they have modified and revised the
Yes, my
Does
lord.
anything
opinion basis
survive?
on it, ma'am.
Actually, nothing survives, my lord. Based on that notification, that memo was not on record with me, my lord. For that reason, I thought that I should produce that notification. Now that that notification is on record,
If it's already on record, then.
and we have already taken action as per the directions of the learned single judge, my lord.
Therefore, can we close this?
My lord, may call it next week, my lord, or it may be closed also, my lord, if the respondents agree.
No, if it, now.
It may be
what-
called
what
on
does-
Monday, my lord. I shall make my submission.
What does the notification say now?
Now the notification has fixed the remuneration as per the Minimum Wages Act and it is being paid, my lord.
And therefore, you don't intend to pursue this appeal any further
That I shall take instructions and make my submissions
this week.
next week, my lord.
Learned
Obliged.
advocate seeks a week's accommodation
Well, yeah.
to get instructions as to whether
Uh,
anything survives in this
14th.
appeal.
14th, my lord.
The light of the later notification
Beda.
list.
My lord, on 19th, my lord. then.
Yes.
Please, my lords.
EDA,
The respondents.
yes. The notification,
My lord, notification
I
of,
think is that notification has lapsed,
Yes.
that the acquisition has become inoperative.
1959 acquisition, my lords. 64 is the final notification. 66, I take possession. Scheme has been implemented, my lords. Invocation of section 27, as with regard to a portion of the survey number which I've acquired. Two survey numbers in question. Survey number 32/1, measuring 3 acres 20 guntas. I'm sorry, my lord, 3 acre 10 guntas. Survey number 32/2, measuring 1 acre 10 guntas. So totally measuring 4 acre 30 guntas. The writ petition is confined to around 16,000 square feet of land in 4 acre 30 guntas. Now, what is being said before your lordships is that one is that the scheme has not been implemented, my lords, as with respect to the 16,000 square feet. Second, my lord, that I have not taken possession in accordance with law as far as the 16,000 square feet is concerned. Some of the questions, my lord, which would arise for consideration of your lordships is that the first is that at the time of acquisition, the father of the petitioners was the notified khatedar in the acquisition notification. The father does not challenge the notification during his lifetime. Subsequent thereto, the children who claim to have succeeded to the property and who claim to have a decree amongst themselves, a suit for partition decree in the year 1987, now seek to challenge the acquisition, whether the locus to challenge the acquisition is available with the LRs. And the principal has not challenged the acquisition is the first question. Second question, my lord, is, can section 27 be invoked for a portion of the survey number to say the scheme has lapsed? The third question, my lord, would be, what would be the impact of delay in approaching this honorable court for challenging the acquisition after 50 long years from the date of final notification? The fourth question, my lord, would be, can the petitioners say that I have not implemented the scheme when I have already proceeded to allot this land, which I had identified as a civic community site, in favor of a third party, which no doubt, my lord, that allotment stood cancelled. But if I have acted upon my acquisition notification, if I have identified a person to whom I have to go ahead and allot this site, can the petitioner then urge before this honorable court that the scheme has not been implemented? So therefore, these questions, my lord, will lie for consideration for your lordship's.
What would be the impact of the finding that they were never dispossessed, they had continued in possession? If that be the fact,
My lord,
in spite of all the legal grounds that you're raising,
my lord,
happens if.
I'm sorry, my lords. My lords, at the time of taking possession of the property was possessed by the father. My lords, then if he has not contested the manner in which I have taken possession and the fact of possession, the legal heirs would eventually only be trespassers on the property, my lord. Honorable Supreme Court has held it in several litigations. If I have taken possession in accordance with law, my lords, the landowner continuing to hold on to the property and the legal representatives there so cannot be seen to be having been in possession of the property. Assuming for a moment, my lords, assuming for a moment, even if I were to go one step further and say this, if it is found, my lords, by virtue of revenue entries or by virtue of the khata issued by the BBMP saying that they are in possession of the property, can it be recognized if in law, if I have taken possession, can there physically, if they are staying in that property, can it be recognized as possession in law will have to also be considered, my lord. If in that event, if it is not considered to be possession in law, then, my lord, I am at liberty to exercise my rights under the Unauthorized Occupants Eviction Act to have them evicted from the property.
What is the finding of the learned single judge?
My lords, if I may request, my lords, there are two appeals here, my lords. One is filed by me, the BDA. Second, my lord, is BBMP has filed this another writ appeal. The reason why, my lord, is that BBMP was not a party before the learned single judge. This land was given to the BBMP by me, being a civic community site, for it to be allotted to a hospital, my lords. Since the acquisition has been set aside, BBMP was also before your lordships by seeking liberty to challenge the said order, my lords. An IA has also been filed by the BBMP trying to bring additional documents on record before your lordships. If your lordships may kindly consider that application and pose this matter for hearing on the merits, my lords.
Yes.
This requires consideration for these reasons.
My lord, acquisition final notification of 964. My lord, now the matter before your lordship is regarding 4 acre and 30 guntas, 4 acre, 30 guntas. My lord, there is a clear finding by the Honorable Single Judge, my lord, to the effect that they have neither taken possession, my lord, nor, my lord, the award was passed. My lord, entire 4 acre 30 guntas of land, my lord, have been abandoned. And all surrounding lands in that particular village has been abandoned. My lord, now only, my lord, a small piece of land measuring about 150 into, my lord, 140 square feet, even out of that 4 acre 30 gunta is before your lordship, my lord. A small piece left with the owners. My lord, in the year 2011, they tried to, my lord, dispossess us, my lord, a small portion. We rebuilt it. My lord, finding it by the learned single judge, page number 24 may be seen. My lord, the order of 2020, after 4 years, my lord, they have filed this appeal. It requires to be, my lord, kindly look at, my lord, paragraph 24. I'll read, my lord, a categorical finding at page number 36. 36, my lord. These findings based on the affidavits filed by the officers of BDA. 3 affidavits have been filed admitting the fact.
Yes.
What remains with the petitioners is only a piece of measuring 115 into 140 feet out of nearly 4 acres 30 guntas of land. It is relevant to notice that all the lands of Govipura village except 32-1 and 32 have been left out of the acquisition proceedings. It is hard to imagine how the BDA, after more than 60 years from the date of the film and notification, is taking a claim with respect to a piece of land measuring 115 into 140 feet, when admittedly nothing has been done with respect of the so-called 4 acre 30 guntas of land, towards which it is stated that award has been drawn and compensation has been deposited before the civil court. Admittedly, no layout is found even in these 4 acres and 30 guntas of land of BDA. No material is placed before the court show that action of the authorities initiated against the entire extent of 4 acres 30 guntas. The concentration is only on the piece of 115 and 140 feet. No material is placed before this court show that statutory notice under 16(2) of the Land Acquisition Act was issued before the taking possession of the land. The Mahajara does not bear the signature of landowner. More importantly, when it is an admitted position that several owners seeking claim that they had purchased big pieces of property, the nature of residence sites, carved out in Survey of 32/1 and 32/2 in the nature of residence sites, and carved out of 13 Survey number 32 had made applications seeking reconveyance of their piece of property. It cannot be imagined as how the special land acquisition officer, having noted that many reasons have staked their claim with respect of bids and piece of property, would say that the revenue surveyor has taken possession of property even without signature original owner Venkat Rao, left alone the other site owners who numbers around 61, even as per the discussion in the award passed by the special officer. The special acquisition officer as well as the commission have admitted in their affidavit, my lord, that the Mahajar country signature of panchas and not the signature of landowners. Therefore, it is at any rate cannot be held that the respondent BD has taken possession of the land in accordance with law. My lord, kindly look at 30, my lord, 28, paragraph 28, page number 42. Admittedly, there's no material with BDA to show that the previous governing provisions governing making of the award and the tendering amount to the landowner losers have been complied with. Most importantly, what is noticeable is even under the award, there is a statement made of special land acquisition officer that the award amount shall be deposited before the court. But there is no material placed before the court show that the award amount has really deposited before the civil court. The land losers were not notified regarding the deposit award, nor they were called upon to collect the compensation. But kindly look at 30, my lord. My lord, now paragraph 34. My lord, before that, the learned single judge discussed the position of law with regard to judgments, my lord. Paragraph 30 may be seen, page number 43. As regards to Mahajar, a learned senior counsel rightly relied upon the decision of so-and-so, wherein it is held that the Mahajar is in a psycho-style form. It is just contains signature of 5%. Neither their names nor their addresses are shown in the Mahajar. Now, can you look at my lord, paragraph 34. Petitioners continue to be in possession of the land. For more than 60 years now, the petitioner continued to pay property tax to the BBMP and all other neighborhood property, which was sought to be acquired under the notification to an extent of 4 acres 30 guntas in survey number 32/1 and 32/2 of Gopur village, is not in possession of BDA. Various landowners who had made their applications and requisitions to the land acquisition officer seeking reconveyance of their bits and pieces of properties have continued to be in possession of without there is any let and hindrance from the BDA. That being the position, the respondent BDA has failed to prove they have complied with the statutory requirement of section 12 clause 2, 16 clause 2 and 13 of the Land Acquisition Act. In the result, my lord, therefore, the court proceeds to declare that the acquisition proceedings under final notification dated 12/22/464 as regards 32(1) and 32 stands abandoned and lapsed, and the preliminary notification. So, my lord, our interest is, my lord, only with regard to that, my lord, a small piece of land. My lord, the
concern appears to be that if this is allowed, the other 61 persons will also come up.
No, that is 61 is not in this. They are not in this, my lord. They are in that village. They are in that village, my lord. My lord, why they have filed appeal now is, during recently, my lord, on 22/4, my lord, recently, in the connected petition on 7/4/12, they have allotted a piece of land to, this piece of land to BBMP.
When is that allotted?
That is on, my lord, 7/4/12, 2012. And my lord, though allotment is there, it was not finally culminated in a registered lease deed or otherwise. They have not complied with the provisions of the act. It's mere provisional allotment. There is no registered lease as required under the rules. My lord, thereafter, violating the, my lord, allotment, that allotment, provisional allotment, they have further sublet the property to particular much, my lord. My lord, now because of them, my lord, the BDA is filing this appeal.
No, that first contention does not appear to be correct, because 1392 of 1964
Please, my lord.
WPC was filed by the then owner, the predecessor in interest, Venkat Rao was filed.
Yes, he filed a writ of petition and he withdrew it.
And he withdrew it, my lords.
Withdrew is because, my lord, their reconveyance
Intention
resolution.
was that they had not challenged.
My lord,
That may
why-
not be correct.
That is not correct.
What I
because-
meant, my lord, was that, I'm sorry.
The reason for the, what is recorded by the learned single judges, because the CITB had undertaken to implement the resolution dated 18/7/62,
Yes.
reconveyance of the land to the landowners. It is relevant to notice that Venkat Rao was the absolute owner of 3 acres 10 guntas and adjoining 1 acre 20 guntas, totally measuring 4 acre 30 guntas.
My lord,
Then-
the reason, my lord, why that has been done so is because kindly see the award, my lords. Kindly come to page number 274, my lords.
Well, before that, can you look at the
I'll
affidavit
just-
filed by them
I'll
before the
answer,
court?
I'll answer my lord's query.
Yes.
The reason why that was so, my lords, was this gentleman, Mr. Venkat Rao, had formed sites without obtaining sanction plan and had sold it to several persons. Now, during the course of acquisition, when I issued notices, my lord, all these persons to whom the sites had been sold by the petitioner's father came to us and filed objections. In the award, I discuss it, my lords. Kindly come to page number 274. The award copy, my lords. There are two award copies are identical for both the survey numbers. So I'll just take your lordships through one, my lords. The award copies are 274.
Yes.
This pertains to survey number 32/1, my lords. Lordship may
Yes.
kindly come to page 275.
Yes.
Serial number 6, notified Khatedari Shri Venkat Rao. My lord, kindly come to page number 277, my lords.
Yes.
Notices under sections 9 and 10 of the LA Act were issued to the marginally noted persons on 3/6/64 and they have been served as noted as against their names. Serial number 4, my lords, Shri M. Venkatarao sent by registered post and delivered on him on 9/6/64. However, father of the petitioner. However, the persons mentioned below have filed their claim applications in this case on the dates noted as against their names. Then the objections are 46 in number, my lords. And kindly come to page 278 after the table, my lords. Most of them have requested for reconveyance of their sites, and very few have claimed compensation at ₹35 per square yard. They have produced only copies of sale deeds. Nobody has filed original sale deeds. My lordship may kindly appreciate this, my lords. The petitioner's father has formed sites and sold, and those individuals have come forward seeking reconveyance, my lord. The moment reconveyance is sought, my lords, then the person seeking reconveyance is accepting acquisition and then seeking reconveyance, my lord. Now, my lord, if the petitioner's father was genuinely aggrieved, my lords, then in the event of non-reconveyance of the land, my lords, the writ petition ought to have been refiled or re-questioned. The acquisition had to be again challenged, my lord. That has not been done. It's a withdrawal of the writ petition, my lord. There's an amendment of his right, or there is an acceptance of the acquisition done by the petitioner's father, my lord. Now, as far as, my lord,
What happened to the layout not formed?
layout has been formed. Banshankari first stage is now with, I'll complete it, Mr. Banshankari first stage, my lord, is in the heart of the city now. It's one of the oldest layouts formed in Bangalore by CITB, my lords. So it is completely formed. There are 6 stages of Banshankari. This is the first stage, my lords. This is a very old layout.
How much is the area actually covered by the layout?
I'm sorry, my lord, I don't have.
There has to be something left out.
But it is huge extent.
It's a
huge
big
extent,
land.
my lord.
Very big layout.
This property is, my lord, even now in the possession of the petitioners. After 60 years, kindly look at their admission, my lord. Paragraph 4.
I'll just complete my submission. This is why, my lords, matter requires consideration. The reason, my lord, is this. Now, my lords, is kindly appreciate, my lords, what the authority is facing. If, my lord, there are always, my lords, when layouts are developed, there are always small parcels of land, my lord, which by their nature of either the size or the shape are not available for our allotment immediately for the formation of a residential site. We have to form parks, we have to form CA sites and other amenities we have to provide. This site in question is a CA site, my lord. Now, it was not immediately allotted, but we have subsequently allotted to others. That allotment stood cancelled by virtue of an failure on their part or another order by this honorable court. Now, my lord, if such petitions, my lord, are favorably considered by your lordships, then, my lord, all those parcels of land, my lord, which I have left intact, being part of a larger survey number, section 27, my lord, if they are invoked for such parcels of land, my lord, then the authority will be put at great loss, my lord. And section 27, lordship may kindly appreciate, is not meant, my lord, to be invoked for a small portion of the land. What section 27 says is, if the scheme is not implemented, what is the scheme in question is under section 15, my lords. Under section 15, it comprises the entire extent of the lands which I have identified for acquisition and the right to the government seeking permission and approval of the scheme. If that scheme has not been implemented, then section 27 will have to. Can one small portion of the site, 16,000 by itself, it's a large portion, 16,000 square feet now in the heart of the city. Can, my lord, section 27 be invoked for section 16 is a question. So 16,000 square feet is a question, my lords. And possession, my lords, as far as possession is concerned, my lords, they claim possession amongst themselves under section 8, my lords. Section 8 was no longer available to them at the time of the death of Mr. Venkat Rao for the reason because he withdrew the writ petition, he did not challenge the acquisition. And my lords, if at great length the papers are to be seen, my lord, it also has to be considered by your lordships that he had formed sites and he has gone ahead and allotted them to several persons. Now, we do not know at this length of time, my lord, after 50 long years, 1964 is the acquisition, final notification. 2016, he approaches his honorable court. Becomes eminently impossible for us, my lord, to again gather all the papers, see what is the extent of the land to which he
Would
had
it not be-
reconveyed.
Would it not be possible, it is for the purpose of a layout? Would it not be possible for you to say that the amount had been deposited in the court?
Yes.
Because there was a civil suit pending
My lord,
at the relevant time.
correct.
For that, it is not
And,
difficult for you that you have, in spite of all these litigations, you've not been able to produce even that.
May I submit this? Assuming for a moment, my lords, that I have not deposited them, I will obtain specific instruction on that. My lord. If assuming for a moment, my lord, I have not deposited, the Honorable Supreme Court in Indore Development Authority says, failure to deposit compensation will not fail the acquisition. What it would mean is that I am liable to pay the compensation amount with interest. With interest.
That's what.
Should it fail the acquisition is, my respectful submission, my lord, is that
Therefore, on the basis of the material on record, we'll now have to consider whether the compensation had been paid, whether the possession had been taken
Yes.
in a manner known to law.
possession, my lord, possession as far as
Had
possession
been
is.
taken in a manner known.
Yes,
to
my lord. How I have taken possession is that, my lord, under the Land Acquisition Act, Section 16 deals with taking of the possession. There are two sections, 1 and 2, as your lordships would be aware of. Under 1, I conduct a mahajar and I take possession. Under 16(2), my lord, lordship may appreciate the language. May, by way of a notification, state that I have taken possession. It is may, I may or I may not do 16(2). But, my lord, failure to do a 16(2) notification will not undo the 16(1), my lord. I have done a mahajar. Mahajar is placed for consideration of this honorable court. However, the learned single judge held that the possession has not been taken in accordance with law. But there is a mahajar. Even the petitioners have produced it. Even I have produced it along with my objection statement. Now, what the learned single judge says is
when was possession taken according to?
1969, my lords.
Yes.
My lord. Now, my lords, what the learned single judge concludes, my lord, is that the signature of Mr. Venkatarao is not available on the mahajar, my lords. Now, my lords, when I take possession, it is not mandatory for me to obtain the signature of the landowner on the mahajar for the reason that the landowner might have an absolute grievance against the acquiring authority for having taken possession. So it cannot be expected that the signature of the landowner will be available on the mahajar. So that one, my lord, is not. It might not be tenable, my lord, to hold it like that. Second, my lord, is that non-publication of the 16(2) notification by itself will not, my lord, undo the position having taken the possession.
The learned single judge also says there are only some signatures. Who are the
Yes.
other witnesses or
Lord,
is also.
Only in psychostyle.
That, my lord, I'll answer it like this. At this length of time, my lords, for me to identify those persons who have taken possession from, who are the people who are, my lords, put their signature on the possession mahajar.
Exactly the point. That if as a matter, if there is a method, a mahajar to be prepared in whatever manner.
Please,
The identity of the witnesses have to be specifically provided in the mahajar.
Yes, yes.
I'll take.
Not there,
Yes.
then the very issue of having taken possession is put in doubt.
Yes. That's a psychostyle form. That's what
It's
paragraph
not a-
30.
I'm sorry, my lord. That is not a cyclostyle form. Kindly see page number 383 filed along with my, the second volume, my lord.
Who's named as a khata standing? Khata,
Not in
khata in the
BBMP.
name of?
Present,
Lord,
my lord.
we have been paying the tax, it is in our name. In fact, the possession is with us. In the year 2014 also, my lord, they tried to interfere. And my
What
lord,
my respectful-
simply now,
my
they
respectful
protect the
submission, my
interest
lord,
of BBMP who
my-
has no
my-
interest at all.
My respectful submission, my lord, is that if the land, my lord, has been acquired by me, my lord, the BBMP recognizing him as the khatedar, my lord, might not in any way undo the acquisition, my lord. That's the reason, my lord, I would like to submit, my lord. When I opened my submission, my lord,
We'll
when-
consider, hear it.
please,
Uh,
ma'am.
Please.
My
Lord.
response, I have a
lord.
submission to make. My lord, if there is some interim protection granted to me for the reason that, my lord,
What?
for the reason, my lord, is that let there not be any alienation of property is all my intent.
My
Let
lord.
there not be any alienation. That's all, my lord, I have to ask.
My lord, this is a matter of 64 acquisition, my lord. Still, my lord, to protect the interest of BBMP, my lord, they are trying to come before a lordship. The BDA, my lord, already saying that they allotted the land to the BBMP.
That may not be right, my lord.
That is the fact. The second.
may not be
picture is
right.
that-
In the, maybe 1 or 2 weeks that it takes to hear the matter, you're not going to sell your
Lord,
property.
at this stage itself, my lord, any date, my lord, next week.
My request,
At
any
this stage.
any
at this-
date,
no, no, At this
any-
stage only, my lord. It may be taken for preliminary, I am ready.
any date after 18th, if I may kindly request your lord.
Yes, this chapter 18,
Let them not,
same stage.
you know, let them
Preliminary.
not alienate it or
No, no,
create
that
any
is not
third
the
party
case, my lord.
incumbents
We are
on the
in
property,
possession.
my
We
lord.
are in possession. We are in possession, my lord. After
If-
Learn Singh ji observed that,
Intend to alienate the property in the next 2 weeks.
my lord, it is not the case at all, my lord. They are nowhere in the scene.
Say that, my
They are
lord.
not, they were never.
That's my
My lord, they have
apprehension, but
filed the appeal in the year 2020. 2020.
the delay has been
The
condoned.
2 weeks, you don't intend to alienate the property. We'll list it after 18.
My lord.
We'll hear it on that day. In the
2020.
meanwhile, don't alienate the property.
No, that will, that we are not doing it.
Yes, learned counsel for the
My lord, that may not be, there is an order on that. Kindly-
respondent submits that there'll be no alienation for the, till the next date of
Yes,
hearing.
yes.
Obliged.
Date. Please.
Obliged.
Lord, for the petitioner, my lord. My lord, this was heard at length day before yesterday.
Few seconds back, I received the file. At the end of serial number 18, I'll make submissions.
May I kindly have it
Peruse and make submissions with that.
Pass over.
2:30, my lord.
2:30.
2:30.
Obliged.
Please, Madam. I'm for the petition in this case. Madam. Petition is challenging the order of the Honorable KAT, my lord. The petition is seeking for death benefits of her husband, my lord. It was died on 7/9/2020 due to COVID reasons, my lord. And the petitioner is the second wife, my lord. My lord, the first wife of the deceased, my lord. That is, she was also died on 28/9/2016, my lord. After the death of first wife only, yeah, the deceased has married with the petitioner on 6/9/2019, my lord. And the deceased, the Srinivas, the late Srinivas, the petitioner husband was died on
He had not made any inclusions in his
Please.
service records, pension book.
No,
nothing.
my lord. That is the reasons.
Page 30 and 31, there are.
And no certificate of marriage either.
Marriage, it's a, as per Annexure 13, my lord, it's certified that there is no marriage registration certificate, my lord. It's only in respect of, please. Translation is that as per Annexure 13, it's a Drudhikarana Patra, it's a certificate. It's not a registration certificate, my lord. It's a 10.
Which is page?
Annexure 13, page number 46, my lord.
These are only photographs. 46, what is
Please.
that?
It's a temple was issued that certificate that the petitioner and the deceased was married, and photos as page number 47.
Page 30 and 31, there are interstate disputes between the legal heirs of father, mother, the first wife's daughter. So it was only relegated to the civil court, my lords. It was not completely knocked off.
My lord,
Page 30 and 31, the finding of the tribunal may be kindly looked into, my lords.
Yes.
my lord, it's not comes under civil court, my
May I
lord.
take note
It's
of it?
admitted fact, my lord, because in the impleading applications filed by the respondent number 5 and 6, my lord, who is the parents of the deceased, my lord, is clearly admitted in the impleading applications that the petition is the second wife of her, is a son, their son, and say, please, I will read that para, but please, I have your one copy, sorry, my lord. I'll read that para, please.
Please read the Tribunal's order first. What is the finding? Please.
It's 30 and 31 would be relevant, my lords.
Endorsement regarding government nominee rule has been issued as per endorsement date 36/21 under R1. And HRMS nomination copies R2. Nominee rule copy R3. Therefore, it is a contention of respondent government that applicant is not entitled to leaves. Respondents 5 and 6 are said to be the father and mother of deceased. Both respondents are daughter from the first wife, Rashmi in the wedlock. Srinivas, Rashmi and wedlock. It is also stated that in the service register, Srinivas, name of the first wife, Rashmi, and mother's name is mentioned. And the daughter, Dhruti, was minor. It is also considered that the respondents are eligible for the benefits.
My lord, in the impleading applications, my lord, that is
Just a moment, which was the endorsement which was challenged before the tribunal?
please, my lord. That is annexure A6, my lord,
Page?
annexure A6. Yes, annexure A6, page number 52, my lord. That is translation copies and that page number 53, my lord. In 54, that is the concerned para, my lord. In this regard, already by reference number 2 dated 2/12/2020, also dated 21/10/2020, told to submit appropriate records. However, till date, no information has been submitted to this office. Also, the said teacher had not obtained permission from the department for his second marriage. Also, just making nomination in the service book. HRMS, there is no provision in the rules to give employment to you. Therefore, letter under reference 1 is enclosed and returned.
Yes.
And she have a 3 years child, my lord. At the time of deceased, she was a pregnant, my lord. She don't have pensionary benefits and pensions, and she is very difficult to lead the life, my lord. And moreover, my lord, the first wife is also she was working as a teacher, and the benefits also the daughter has taken, my lord.
That may be correct, but then the finding cannot be said to be incorrect. Looking to these contentions, have not admitted that the applicant here lived. So and so cannot be ascertained. It's only a civil suit before the civil court. Status of marriage, does it not have to go to the family court? No.
They've given the liberty, it is only in a civil suit before the civil court wherein the LR applications can be granted. So it's not been completely knocked off. The case of the petitioner herein is not completely knocked off, my lords. It's been relegated to the civil court to actually adjudicate the interstate dispute. We have also provided the employee service details, my lords, at annexure R2, wherein the father, mother, the minor daughter name has been mentioned actually, my lord.
When the admitted fact is
Annexure
proved,
R2,
my
my
lord,
lords,
it's not.
because the paginations differs in my petition.
Mm.
So annexure R2, what's been produced in the present petition may be kindly looked into, my lords. The second page in the said annexure, my lord. Rashmi R family member, Jayama family member, Rashmi R again. Then in the second column, father's name is there, minor daughter's name is there, the spouse name is there.
My lord, one submission, my lord. It's already admitted by the respondent number 5 and 6 in the impleading applications. I will read that para. It's only one copy. I'll give that, please, my lord, please.
Will not make a difference.
Please, my lord.
That will not make a difference now.
Please,
that they've
sorry, my
raised
lord.
a-
That copy has not produced. Sorry, extremely sorry, my lord. I have that copy. Impleading applications filed by the respondent number 5 and 6 before the
5 and 6
Karnataka.
are the parents.
Yes, my lord. They are admitted that the petition is the second wife. Please, I will read one, please, 4 lines, my lord, please.
They read, admission will not make a difference. He has not made any nomination and you don't have a certificate of marriage.
My lord,
It will have to be decided in a civil court before.
Lord,
anything
after
can
the
be
death
done.
of first wife only, he has married with the petitioners, my lord.
Correct, counsel, but there has to be a finding of the marriage because there is a minor child by the first wife.
Yes, my lord.
And how would you be entitled to the entire benefits if there is a minor child? There is a mother. All these are matters which now have to be decided as to the entitlement for the benefits will now have to be decided.
My lord, one more, my lord, they have filed an affidavit. They have given a affidavit, it's a Kannada, my lord. I will produce the documents.
Who has given affidavit?
Respondent number 4, respondent number 5 and 6 and daughter, my lord, please, I will produce that affidavit
What do they
next
say?
time, please, in the Kannada.
What do they say? Please read.
My lord, it's in Kannada.
Yes, please read it.
ನನ್ನ ಮಗನಾದ ಲೇಟ್ ಶ್ರೀನಿವಾಸ ವಿ ಇವರ ಎರಡನೇ ಪತ್ನಿ ಶ್ರೀಮತಿ ಸವಿತಾ ಏಕೆ ಇವರು ದಿನಾಂಕ 6/9/2019 ಹಿಂದೂ ಸಂಪ್ರದಾಯದಂತೆ ನಮ್ಮ ಕುಟುಂಬದ ಒಪ್ಪಿಗೆ ಮೇರೆಗೆ ಮದುವೆಯಾಗಿದ್ದು, ಶ್ರೀನಿವಾಸ ವೀರವರು ತಾರೀಕು 7/9/2020 COVID-19 ಕೊರೋನಾ ಸಾಂಕ್ರಾಮಿಕ ಕಾಯಿಲೆಯಿಂದ ಮರಣ ಹೊಂದಿರುತ್ತಾರೆ. ಆ ಸಮಯದಲ್ಲಿ ನನ್ನ ಸೊಸೆಯಾದ ಸವಿತಾ ಹೇಕೆರವರು ಗರ್ಭಿಣಿಯಾಗಿದ್ದು, ತಾರೀಕು 14/10/2020 ಸಾಮ್ರಾಟ್ ಎಸ್ ಎಂಬ ಗಂಡು ಮಗುವಿಗೆ ಜನ್ಮ ನೀಡಿರುತ್ತಾರೆ. ಶ್ರೀನಿವಾಸ್ ವೀರವರ ಮರಣ ನಂತರ ಸಿಗುವ ಅನುಕಂಪದ ನೌಕರಿ ಮತ್ತು ಪಿಂಚಣಿಯನ್ನು ನನ್ನ ಸೊಸೆ ಶ್ರೀಮತಿ ಸವಿತಾ ಏಕೆ ಇವರಿಗೆ ಕೊಡಲು ನಾನು ಮನಃಪೂರ್ವಕವಾಗಿ ಒಪ್ಪಿರುತ್ತೇವೆ. ಇದಕ್ಕೆ ಪೂರಕವಾಗಿ ಕುಟುಂಬ ವಾರಸುದಾರರ ಸರ್ಟಿಫಿಕೇಟ್ ಮತ್ತು ಅಗತ್ಯ ಇರುವ ಎಲ್ಲಾ ದಾಖಲೆಗಳನ್ನು ತೆಗೆದುಕೊಳ್ಳಲು ನಾವುಗಳು ಅನುಮತಿ ಕೊಟ್ಟಿರುತ್ತೇವೆ. It's clear admitted, my lord. That's why I said, please. I will produce this document, my lord,
They'll
along
produce
with
it, but then they will
translation.
have to be put on notice. And if they retract from that, that will be the end of the matter. If you can, as a matter of fact, if they can come here and if they also agree, something probably can be done. Otherwise, it will have to be decided because you don't have a certificate.
Minor
He did not
daughter-
make a nomination. All he had to do was make a nomination showing you as the second wife. If that had been done, then all these problems could have been avoided. He did not.
Marriage is not your dispute in this case, my lord. It's only she's not living with her husband. It is the dispute, my lord. That's why, my lord. I'll produce on citations on next date, my lord, along with the translation copy, please.
Notice has to be,
Please,
they have to come on record.
please, my lord.
Notice to the private respondents. 4 to 6. They're on record. The wait is there. Have you served? No. There is a caveat. Please serve on the caveat.
Please, my lord, I'll serve.
Yes, petitioner shall serve copy of this petition on the learned council. Appearing in the caveat petition. List after a week, please. And produce whatever you want to.
Date, my lord. Please.
Matter pertains to my lord's promotion to the cadre of Deputy Director. I pointed out, my lord, 7 posts of Deputy Directors. My lords, 2 are already filled up by candidates belonging to SC and ST. Now, my lords, again, another 2 my lords are recommended for promotion by DPC. And I am informed that my lords, the orders are also passed, which I sought from my lord stay, my lords, by filing an application. My case is, my lord, that it is almost 60%, my lords, considering the reservation which is given to my lords, scheduled caste and scheduled tribe.
If it is considering the reservation, you can raise these contentions. If they've come there on their own merit, how can you?
Not on
contend?
merits. They were, my lords, below me. They were considered for the reason that they belong to scheduled caste and scheduled tribe.
All are juniors.
My
according
lords, 3 are juniors. 1 is my lord senior. In fact, my lords, first 2 were promoted. Later on, my lord, the post was redesignated. Now, my lords, those who are juniors to me, my lords, are sought to be promoted. My lords, in fact, my lords, the learned government council, my lords, who appeared, made a submission that, my lord, it is because of change of the roster points, my lord, this issue has come up. And in fact, it was admitted that there are more number of candidates who are considered.
If
My lords,
it
they
is-
were directed to my lords file reply, they have not filed it. Instead, my lords, they are passing orders, my lords, to promote the private candidates. Till this day, my lords, they are not committed anything on record by filing statement.
7 posts of deputy director, junior scale administration.
Please. Now, 4 posts are filled up. My lords, let's assuming that, my lord, the first post is given to, my lord, the person belonging to scheduled caste. A GM candidate should have been considered, my lords. Instead, my lord, In the first case also, one SC and one ST. Second case also, my lords, SC and ST.
My colleague who appeared in this matter is indisposed, my lords, a short accommodation.
My lords, application for stay is, my lords, fine. And my lords, they take time, my lords, for filing objections. Issue an order, my lords, promoting, my lords, which I sought for stay, my lords, by filing an application. Nothing happens, my lords, if there is stay, my lord, till they file their reply and it is considered by this honorable court.
Tuesday, my lords, morning, I got the intimation that he was indisposed.
The stay was to filling up the 2 further posts. That was the stay you had claimed. Now that is done.
But I
So-
challenge the, my lords, the findings of the DPC, my lords, recommending their name and rejecting my case. And my lords, as my lords, specifically, there was no stay of the recommendation sought. I had to move an application, my lords, for the relief.
Yes, learned government advocate seeks a short accommodation. The learned counsel for the petitioner submits that no objections are on record to the stay application as yet. List after a week. The promotions which are made to the cadre of deputy director
My lords, if my lords are inclined to give the.
shall be deputy director,
My lords,
Did-
administration.
administration. During the pendency of this petition will be provisional and subject to further orders.
My lords, may indicate a date.
Yes, list after a week.
Yes, my lords, week after next, any date.
Yes.
Published.
Yesterday's matter, my lords. A colleague had made submissions, so Tuesday is coming back. This afternoon only is making efforts to come back, so Tuesday, my lords.
Yes.
Big leave. Notes my order of transfer at 171. This was sought to be set aside by the tribunal, the ground that there was no counseling.
Post from where to where?
Notes to General Hospital Tiptur, from General Hospital Chiknaik. Notes the private respondent, my lordships could see, he was working there prior to me. That is the 5th respondent here. Notes he had challenged the same before the appellate tribunal, my lords. And the petition is at 157. Initially, my lords, there was an interim order passed by the tribunal at 176 for a moment. Notes that, my lords, was challenged before this honorable court. And my lordship will see the electronic copy at 193 minutes for a moment. This explains the set there, my lords. Now, my lords, the premise on which, the ground on which, my lords, I had sought for transfer was, my lords, that my husband works there. And we had an autoimmune child who suffered from a rare disorder. I've just mentioned that. We said, together, my lords, we needed a place where we can take care of the child together. That was one of the reasons. And that was the reason for the previous interim order also. That's the ground on which, my lords, the appellate tribunal, the administrative tribunal, my lords, sets aside the transfer, my lords, says there is no counseling. So which, if I may just take your lordships to the tabular column at running page 16 for a moment. I've extracted the tabular column at 16 for a moment. In the order of transfer, my lords, there were only 4 ENT doctors.
Yes.
My lords, that order, I've mentioned the entries also, my lords. Entry 3, entry 4, entry 19, entry 44. My lords, one of the doctor, my lords, that is Dr. Shiv Kumar, my lords, he was, my lords, given a better post within the same organization, that is entry 19. Then one Dr. Vani had left her job, and in her place, Dr. Sunil Kumar was inducted. That is also 44. Remainder, my lords, was only the petitioner and the respondent number 5. So even, my lords, if there were to be a counseling, my lords, the respondent number 5 would not have tendered his consent. And, my lords, the respondent number 5 had continued therefore right from 2015. We wanted that transfer because, my lords, both husband and wife could stay in one place and the child could be taken care. That is the reason. That is the reason. Now, my lords, the tribunal, my lords, initially, my lords, recorded a finding that let the matter before the High Court get culminated. That is at 196 for a moment. Somehow, my lords, in a batch of matters, it was decided. This was also taken up and disposed of with a common order. 196 for a moment, my lords. The order dated 18/8. It was meant to be taken up after the earlier writ petition, which is still pending. And this order has now, a final order has been passed, my lords, by the tribunal, which is assailed.
What is the finding?
This finding, my lords, is there is no counseling. There is no counseling. Let's at 65 for a moment. This is where the finding starts. The aforesaid various decisions stipulate that transfer of medical orders has to be done only through counseling by the competent authority, and any other method is impermissible. Hence, it is clear. Authorities have not only violated the rule of law and acted contrary to the dictum of the Honorable High Court and this tribunal in this regard. View the fact that the order posting the 5th respondent issued by the first respondent is in utter contravention of Act and Rules 2011. Said order is without there being any power or authority and in derogation of the Act and Rules of 2011. It's an admitted
So
fact.
now you are in the old post itself on the basis of the interim order.
Because in terms of the interim order, I have been serving in the place where I was transferred to.
The counselings are on.
The counselings are yet to commence. This year, the counselings are yet to commence.
Only the mismatch counselings have occurred. Yet, only the mismatch counselings have occurred. The others have not taken place. The counselling has started, has it not?
I'm told not yet. It is on the cusp of it.
There are other writ petitions with regard to the same year.
Please, minutes. There are, because there were certain 97 people, who were
Mismatch and
affected.
rural has already been done.
Please.
Now the next round of counselings is due immediately. So if in the counselling, you are granted the same post, that is the end of the matter.
Till then, till the counselling is done, I think.
It's a special case of the child having a special condition, my lords. We
Yes,
won't oppose.
it is submitted by the learned counsel for the petitioner, that the petitioner is presently continuing as specialist ENT in the general hospital.
Tip 2. TIP.
Tip 2 in Tumkuru district on the basis of the interim orders passed by this court. It is further submitted that the counselling for transfers is due to be conducted in the department soon. List after. Have you taken out notice? Should you take out notice to the other respondent, or
Private respondent may.
shall we await the result of the counselling? If that settles the issue, that will be the end of the matter.
Please, it could. Till then, that protection is what I require. That is all.
Yes, list after 3 weeks. Let's
And
see
till
what
then, I
happens.
may continue.
The protection granted by this court shall continue till then.
Protection granted
Granted by this court shall
in
continue.
the earlier writ petition. In the earlier writ petition, WP number.
You are as a matter of fact there now.
Yes, yes.
You're sure?
Yes, yes.
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 In
And it may be
above-
stated online.
in those circumstances,
submissions.
the present posting of the petitioner shall continue till the next date of posting.
I'm grateful.
My lords, on 19/7/2024,
Hmm.
a statement was made by the government advocate that differential treatment of geologists similarly placed. Why we have to answer that issue, my lords. Next week we'll answer the issue, my lords.
I'm told that
19
the learned government advocate arguing the matter is.
is indisposed today.
But may I request next Wednesday, Wednesday.
No issue.
Very short point, my lord. Out of, my lord, 30, 8 have been regularized from retrospective date.
Yes.
Prima facie, my lordships agreed with the view of the petitioner, so we had to substantiate the issue, my lords.
Yes, learned government advocate seeks a short accommodation. List on Wednesday.
Very much, ma'am.
Please.
But your lordship was pleased to direct the other side to get instructions. But it's a case of not premature transfer.
The earlier, yes, yeah, granted, the first time notice has to go in that earlier case. It was good. Yes. Yes,
The last date, your lordship was pleased to direct allotment to take notice and get instructions.
I'll try to get it by 2:30, my lords. Try to get to the instructions.
One more.
Appear for the petition. Therefore, it was a transfer model. So yesterday, my friend, the accuser killed. So it was a transfer without posting, not that your lordship is that 30. Like,
this was listed for instructions today,
like, you know,
so without posting.
Yeah, I read the impugned order, my lord. 6 months, within a period of 6 months, it's been transferred without a posting as such, my lord. Kindly have it on Tuesday, I'll get the instant. These matters
No.
got assigned to me at the last minute, I'm a little handicapped, my lord, so I'll just.
Tuesday.
last, Monday, not please. No,
Monday
because
is a bit
without
diff-
posting, not that the order may be, the order may be
Or I'll
stayed.
make
but
an
getting
attempt at 2:30, my
instruction.
lords. I'll
See,
make an attempt at 2:30.
I relied
2:30
upon
I'll
the division bench judgment of this honorable court.
2:30, let's make an attempt at two.
I'll
2:30.
try to make an attempt at 2:30.
Yes.
2:30.
2:30.
Appear for the.
Filing
Your
delay.
lordship,
Notice has to go. Notice has to go, filing delay.
your lordship, delay is there, but they have filed the execution. Anytime they may throw me out, your lordship. 40 days delay is there, but it's expiry degree within 2 days. And the notice has been served on 20th. On 20th, the judgment has been passed. My client was not knowing where is the commercial court. He has gone to the city civil court and the judgment has been passed here, your lordship. Now they have filed already, they have filed the execution. Execution 201 of 24 is pending before the commercial court. They may throw out, your lordship.
What is the decree?
Suit for suit for injunction they have filed. The degree is he has to pay amount of 7 lakh 51. Already we have divided 3 lakh rupees, your lordship, and 15 is damages. And he had to vacate the premises. That is the degree passed by the lower court.
3,000 per month from date of superintendent.
The actual rent is 30,000 rupees. And up to date we have paid the rent. He's taking cash. Again he has filed that you have to pay around 3 years of arrears of rent. It's a expert degree, and the court was pleased to pass the entire amount arrears of rent of 7 lakh 50,000. Actually, we have to pay only 30,000 rupees. And we have, even to an extent, we have paid 15,000 rupees tax. That is pending for the honorable city civil judge. At this solution, they have filed execution in 201 of 2024. They may throw me out anytime, your lordship. It's a commercial property.
Heard the learned counsel for the notice in the delay petition as well as in the appeal and in IA 2 of 2024. Having considered the contentions raised on behalf of the appellant, there will be a stay of further proceedings in execution on condition that the appellant remits 50% of the decree amount
So the 3 lakh has already been deposited, 3 lakh is deposited.
Whatever has been deposited can be, on condition that the petitioner shall deposit 50% of the decree amount before the court below within 4 weeks. The amounts already deposited shall be taken note of.
Yeah, 3 lakh is, will help. 6 weeks, your lordship,
6 weeks.
6, much more.
Conditional order need not be passed. Yes. Condition is not there. There'll be an interim stay till the next date of hearing.
Much more.
The appellant. Defendants appeal, mirror, suit for eviction, and 2 months' time was granted for eviction. I am only seeking extension of time of 6 months. She want to make alternative arrangement.
Are you paying the?
Yes, I am paying. Now the commercial court has enhanced the rent from 50 to 60,000. That difference is not paid. And otherwise, I was regular in payment. The commercial court has also observed. And only 2 months' time was granted. I was requesting the respondents for extension of time. They didn't agree, and now they have filed execution petition for execution of the decree. It is a commercial premises. She is carrying a electrical business, mirror.
Delay of 121 days.
121 days. I was approaching the parties for extension of time. They didn't agree, and now they have already filed execution petition, mirror. And IF2 for dispensation, I have produced the certified copy now. I am not pressing that application. I have produced the certified copy of the judgment and decree.
IA3 not pressed. Dismissed. IA1 and 2. No, IA.
One is for
IA2
condonation of delay.
Yes, 2 is dismissed. 1 and 3 notice. Yes, the amount has to be paid. Has it been
Yes,
paid?
that 50% I will pay now. 4.5 lakhs.
There will be a stay of further proceedings till the next date of hearing on condition that the appellant remits half the amount as decreed. 50% of the amount as decreed.
Please.
Within 2 weeks, you've already paid.
Pardon me?
You said you had paid some amount.
No, that is, no, regular amount was paid, difference was not paid.
4 weeks.
Please, before this honorable court or before the commission? Before this court.
Before the commercial court. Before the commercial court. Before the commercial court.
Yes.
The amount shall also be kept in FD.
Under auto renewal scheme.
Pass over, my lord. I have engaged age in this matter, my lord, is held up in election in other court, my lord. Pass over, my lord.
61 days delay.
One submission. Let this delay application be allowed. I file my objections for the application. This matter may be listed next week.
My lord,
In the meantime, let the.
there's
records-
an urgency in the matter, my lord.
Let
Is
the
the-
records be called for. We will go.
What
go
is
ahead.
the-
Till then, let them not alienate the property, my lord. If that order is there, I have no objection to file it next
Nothing
week, my lord.
happens within a week.
Till then, they let them undertake that
Within
they'll
a
not
week, we'll have it
alienate
next
the
week.
property.
Please,
If you're stating that nothing will happen within a week, we'll have it next week.
Please, nothing will happen.
yes.
Nothing.
Kindly, it may be recorded, my lord, that statement that
Learned counsel for the respondent seeks time to file objections to the IA. The delay can be controlled?
Yes, it may be
IA 2 of 2024. IA 1 of
I'm
2024.
filing an IA under 39 rule 1 and 2. I'll file it in the counter. my lord.
Yes. IA 1 of 2024. Having heard the learned counsel appearing on either side, and in view of the averments made in the affidavit filed in support of the IA, the delay of 61 days in filing the commercial appeal shall stand condoned. IA 2, learned counsel for the respondent seeks time to file objections. Call for the records list after a week. In the meanwhile, the learned counsel for the respondent submits that there will be no alienation of the property.
Much obliged.
Appearing for appellant's counsel.
604 days.
Yes, my lord.
Notice has to go.
Yes, may I make one small submission, my lord? Some urgency in the matter. Permit me to take out notice to the councils appear before the trial court, the respective parties. Secondly, my lord, I will take out emergent notice. A returnable date may kindly be indicated on or before 18th of this month. In addition to that, my lord, I will take out hand summons to the defendants. All the three modes, my lord, I wanted.
Yes, 2 modes is common. 3 is very rare. Yes.
The delay we said, my lord, it's a commercial. One of my friend who undertakes to settle the matter between us. Several rounds of deliberations have taken place. While the matter was in progress, my lord, my close friend, which I have trusted, he parted from my company and joined with the other side. And he could not have informed all those things. We realized it later, my lord, he somehow committed some mischief on us. Then we realized that something other intention behind them, therefore advised the client to file an appeal. There is a delay in that piece. Commercial transaction, my lord, all are in the film production field.
Commercial transactions, 604 days.
Film
That is the difficulty.
production field. my lord.
Yes. Issue notice to the
18th
urgent
Sunday.
notice. Yes, the appellant is also permitted to take out notice by hand summons and by serving on the counsel appearing in the court below, in addition.
A date, my lord, 19th or 20th, 19th. Very grateful.
Lord, arbitral award is set aside. The challenge is after a gap of 600 days. So need notices to go. Notices to go.
Notice.
Obliged.
Yes. Whether there be any purpose is now the question. Anyway, notice.
Actually,
Your lordship, I had not raised the contention in the tribunal. Can I raise it? It's that one.
Same
Sure.
difficulty that my colleague had raised this contention. It's Tuesday or Wednesday.
Wednesday.
May I make this request? Could it be very well, Wednesday, I think, because my lord, your lordships had heard it for quite some time, and it's only on that issue, my lords, whether it has to be remanded. Very well. Great. Interim order. Great.
Go on with this one.
The record has been secured, my lords. Whether the state, actually, the Lokayukta advocate made a request for 230 months.
Yes, it's posted at 2:30.
But the state has complied with the granting of pecuniary benefits, so it might not
There may
survive.
not be anything further.
230, my lords, 2 minutes. my lords. This I requested for 230 members. Both instructions I had to secure on the transfer issue. 18 also. Kindly pass out, senior counsel is engaged, kindly pass out, we will come.
What is the matter?
It's a service matter actually.
Notice to R3 to 21 dispensed with.
Not, they have placed, they have appointed, we are not actually disputing their appointment.
Mm.
So hence the memo is filed to dispense the notice, kindly pass out, the senior will come.
This
Senior
is
counsel-
selection, is it?
Yes, selection. KPSC selection, my lord. Selection at the hands of KPSC.
Hmm. Can be taken up when the matter is being heard. You're ready?
Ready.
Pass over.
Correct.
Let's pray for a short accommodation, Monday or Tuesday. My apologies.
Some emergency, my lord, since so far, because he has retired in the year 2015. Till to date, notes, no pension has been settled upon.
There is a disciplinary inquiry.
They are disciplinary inquiry.
What is the penalty?
The penalty, my lord, recovery of an amount of rupees 6,62,000, my lord, second. The allegation is that
62,000.
6,62,000,
What about the remaining amounts? Not disbursed.
not disbursed.
Why?
No, an inquiry was held against him by saying, there's an allegation by saying that he has illegally disbursed an amount of rupees notes under the various schemes.
Therefore, the penalty imposed on you is only
6,62,000.
6,63,000. Rest of the amount has to be released.
Not even notes, there's an instruction.
Once the disciplinary inquiry is completed, imposing a penalty of recovery alone, then the
To that
pension,
extent,
pensionary benefits,
my
everything else has to be released.
Not even a single 5 notes has been released in his favor.
Are you sure?
Please, ma'am. In fact, ma'am, they instructed the bank. He had an account notes in Elbuga in the SBI.
Hmm.
The third respondent, Panchayat, has instructed the bank not to disperse an amount. I was surprised. That's the reason once I had made a request even at the initial. Let it.
Respondent, Taluk Panchayat.
Taluk Panchayat.
You've taken out notice?
Yes, it has been served.
Appearance? Just appearance? There is no appearance for R3.
There is no appearance.
How can that be? After the penalty is only with recovery, there cannot be a direction that other amounts shall not be paid. He's entitled to full pension, he's entitled to all his other PF, DCRG, commutation, everything, except withholding 6,33,000 or whatever is the amount for.
Quantum of penalty, remaining amount should be disbursed. We'll clarify next week, my lord, with
Yes,
regard to this. aspect.
Learned advocate seeks time to get instructions with regard to the payment of the remaining amounts, less the amount deducted as penalty to the petitioner. Remaining retirement benefits, less the amount deducted as penalty to the petitioner. List next week.
Let date begin.
Next
If
Friday,
you're-
my lord.
If you're ready in the matter, the question
ready,
with
miss, I'm
regard to
ready.
the penalty, that also we can consider.
Please.
But even in the meanwhile, all that can be now recovered from you is the
Please,
amount
yes.
found as penalty.
Please.
20th. Good.
20. Yes.
Good.
I'm appearing for respondent number 2, my lord. May I request for a short passover, my lord.
Why?
This matter can be disposed of.
Yes. Why do you want a shot? Yes.
I get. Strangely, my friend wants a passover.
Which is this?
But for the first time, my lord, it is being disturbed.
Yes. You want it on some other day. We'll have it next week.
Passover.
Passover may not be able to reach. I've passed over quite a few matters today. 2:30, I think 4 or 5 matters have been passed over.
No. I. But Next thing. Yes, it is.
Why is there a dearth of counsel here today? This normally does not happen. Let's, which again is surprising. Yes.
Respond number 5, my lord. Influxes ಆಗುತ್ತಿರಲ್ಲ.
For the petitioner, my
Ready?
is pertaining to transfer, my.
I had to answer, my lords. The contention, what was stated on Wednesday is KSAT reverted my lords, the conclusive part.
What happened in this matter is,
One
my lord,
second, my lords.
the KIT was allowed set aside the posting out of the fifth petitioner, fifth respondent, so far as the petitioner, fifth respondent is concerned. But was reserved to the government to take a posting out afresh, my lord. The government, what happened, my lord? The government was dead, neither considered the fifth petitioner and fifth respondent. Somebody has posted and somebody is working there, my lord. It was passed on 10/6/10/2023, my lord. This was not subject matter before your lordship. That aspect of the matter, man.
Just a moment, learned counsel for the petitioner submits the petitions presently without posting orders and that the contention of the respondent that is being given posting as first division assistant in the office of the district health and family welfare office, Davangere is
He has given a
factually
posting. He has given a posting.
I will answer, my lords, because it was the government which had to do so. What's happened between them and them, they had a issue list before the KSAT. KSAT finally adjudicated and told you revert back to the original places. So the complaint made by the petitioner now, it's the petitioner's application which is being impugned by the petitioner in the writ petition also. So the reversion is to the original places as such. So now I also took through my lordship with regard to the closing of the contempt petition because we had abided by the orders of the orders of the tribunal as such. Now the statement was made in open court that he is without posting as such. So what we have done, my lords, as soon as the tribunal's order was passed and also a contempt petition was filed, that with regard to the operative portion of the tribunal's order, we are not giving effect to. So while our order dated 4/1/2023, we wrote to the petitioner telling him, you can go back to your original place, which till date he has not done. So what happened again on 16/1/2024, we communicated to the petitioner, though we have told you to revert back to the original place of posting as per the orders of the tribunal, you have remained absent. In lieu of the unauthorized absence, now the only remedy for you to get back to a posting would be, as per our prevailing rules, you have to approach the Director of Health and Family Welfare. So government can't be faulted because we told them and we told the petitioner and gave him an option to revert back to the original place of posting, which he did not do. It's in vernacular language. May I pass the same to his lordships for perusal, my lords?
Yes.
Only 2 annexures as such.
Yes.
About my lord, in the KIT order itself, my lord, there is this clearly given a specific direction, my lord, with regard to applicant as well as the petitioner, fifth respondent. So lordship gets your page number 73, my lord. For which, my lord, the fifth respondent already reported is working there, man. I don't have any grievance with regard to this order, man. Moreover, I did not challenge this order also. The applicant is concerned, I did not report it at all. That about, my lord, the applicant worked in this very same place since 9/12/2015 to 26/2022. Nearly 7.5 years he worked.
No, that may be, but application is allowed notification bearing so and so. 26/22 issued by the third respondent is set aside.
Counseling was.
Insofar as it relates to transfer of the applicant and the respondent. However, liberty is reserved to the respondents for initiating proceedings for transfer as per Act and rules.
For this liberty, my lord.
That reverting first has to take place.
Please, my lord. This liberty, my lord, government has conducted counseling, somebody has posted there. Neither consider the place of the petitioner nor the fifth respondent there. So.
The first event did not happen when we wrote to the petitioner to revert back to the original place of posting as such.
When did you? When
I
was?
passed on those.
Just a moment. This is on 28th September 22.
Yes, my lord.
In the January 23, what I passed on to his lordship, we have intimated to the petitioner to report to his original place of posting, my lords, which he has not done till today.
In the tribunal order itself, my lord, there is a clear one. Page number 73, my lord.
We implemented the tribunal's order asking the petitioner to report back to his original place of posting. I've given that said communication, my lords, which not been availed of by the petitioner. So in 2024, we treated the same as unauthorized leave and told him to report to the Director of Health and Family Welfare if he wants a current posting as such, because that's the rules of the government.
That also is not done.
That's also not been done.
I made representation, like produced.
That representation will not do.
No, I appeared before the director and I made representation to give me posting. Even thereafter, they did not give me posting.
What is the finding of the tribunal? Please.
Fine.
Page 73 is the operative portion, my lords.
Posting of
It's 72 and
private
73,
respondent to my place has been quashed, my lord.
concise order as such.
Setting aside the order, applicant and fifth respondent shall work in their respective earlier places till they are given posting after following the procedure as per. In the contempt, the contention was that tribunal is directed that also receipt a certified copy of the order. Complaining gave a representation on 3/10/22 to the district health and family welfare officer. Issued an order as per directions, and the complainant was working as first division district was immediately posted to his earlier place of posting. The order of the tribunal is included once.
In para 4, they themselves stated that I was working as first division assistant at.
As
Will
seen from
choose.
the cost title in the main application, the applicant was working as first division assistant, primary health center, Velichudu, Jagalur Taluk, Davangere district, and was on deputation as FDA in Deputy Commissioner Office, Davangere. Therefore, in compliance with the tribunal orders, the respondent director of Family Health and Family Welfare, Government of Karnataka, posted the complainant by order dated 11/1/2023
I've placed the order on record.
to his original place of posting, which was at Primary Health Center, Belichudu, Jagalur, Davangere. Again, such liberty was given to the respondent accused to further transfer the applicant. He is now placed as First Division Assistant in the Office of the District Health and Family Welfare Officer, Davangere. The two orders placing the complainant as the original place and later in a subsequent posting as per direction did not see any non-compliance or disobedience. There has been full compliance.
My submission
Yes.
is that had I not been posted at Davangere, I had no occasion to challenge the transfer order of private respondent. I have no locus at all. Since I was reported at Davangere, that was my place of working as on the date of filing application before the Honorable Tribunal. Though the cause title may say something else, but according to the papers available in the before the tribunal, I have reported at Davangere on 21/6/2022. Had I not been reported at Davangere, I had no occasion to challenge the transfer order of private respondent because I am not at all an aggrieved person.
Correct, whatever that be, you suffered the dismissal of the contempt application also,
Please, madam.
because you were posted to your initial place of posting.
That
That-
was
You did not appear, you did. Then later you were given a posting at Davangere itself. There also, if you don't,
no, my lord. I did not give posting Davangere at all. Had I been given
you-
posting at Davangere, I would have worked
how
there,
can
my
you
lord.
say that? That is recorded by the tribunal.
No,
and
no, my lord.
the
It
Contempt
says
is
that
closed. The tribunal says there's a later order. Is there
Yes.
such a later order?
This is on 11/1/2023,
Yes.
in which it is stated that on 5/8/2022, afternoon, the primary health center, Malkere, Davangere, is doing work in that place.
My lords,
11/1/23 is the
11/1/23.
date of the order. No? And
11,
here what does it say?
KG Satyanarayana FDA, that is first,
That's the petitioner before this court.
is directed to report his duty as per the KT order. In Bilichod, Jagalur Taluk,
Bilichud,
We
my lord.
did give effect to the orders of the tribunal. That's the communication what's been reproduced in the contempt proceedings, my lords. I've also produced the communication for the perusal of this on the report.
Then you later transferred him to
No, we
Davangere.
didn't do anything because he didn't report to the original place of posting is my instructions as such.
What is this?
That is the action what we have taken because of his
Unauthorized.
unauthorized absence, which is also served on him.
At any point of time, they did not post me at Davangere, my lord.
This letter is issued on 16/1/2024 to the by the district health officer, Davangere.
Now the tribunal which passes the order in your favor
Please, ma'am.
is satisfied with the order passed on 11/1/2023. The tribunal says there is no contempt. You want us to hold that there is contempt. Why didn't you just go and join duty? Now that you've been asked to go and join duty, at least now report before the director.
I made,
Be given a posting.
even I made representation before the director on 9/5/2025, seeking for a posting. Even thereafter, they did not give me posting till date.
You cannot send representations. You have to go there
I reported also,
yourself and seek posting.
personally reported. Thereafter, I sought for a posting, ma'am.
May I suggest one thing, my lords? Let a date be fixed by this honorable court for him to comply with what the notice we have issued on 2024. So let him go at a fixed time fixed by this honorable court.
Please,
I
my
expect
lord.
the same
Please, my lord.
to the concern to take it to consideration.
The learned counsel for the petitioner contends that the petitioner is still without posting orders and that he has made representations before the concerned authorities but has not been given a posting in spite of the directions issued by the tribunal. The learned government advocate submits that after the disposal of the application filed by the, after the disposal of the application by the tribunal, the petitioner had filed a contempt of court case before the tribunal. And by letter dated, and the respondents, official respondents had appraised the tribunal that by letter dated 11/1/2023, the petitioner was required to report for duty at the primary health center, Pelichudu, Jagalur Taluk, which post he was holding substantially. It is
Originally,
Because
originally.
was holding, that was a
Agreed,
post
my
he
lords,
was
agreed.
holding substantially
Agreed, ma'am.
at the time when the impugned order of
Very much.
transfer was passed. It is submitted that accepting the said contentions, the tribunal had closed the contempt of court case. It is submitted that thereafter also, the petitioner did not report for duty and proceedings dated 16/1/2024 had been issued requiring the petitioner to report for duty,
No, to
report
report
before
for
the
director, family and health.
director, family and
Director, my lords, I'll just tell the nomenclature.
family and
Department of Health and Family, my lords. Department of Health and Family Welfare
the
Services.
Department of Health and Family Welfare Services for appropriate posting. Though the learned counsel for the petitioner submits that he had actually reported before the director
please, ma'am.
and had made representations, the learned counsel, learned government advocate submits that it is, the learned government advocate submits that if the petitioner appears before the director and seeks appropriate posting orders, such posting orders will be given.
Will be considered
Considered.
with regard to the rules applicable, my lords, because he has to answer about the unauthorized leave also. my
The
lords.
question with regard to posting will be considered in accordance with law. Full stop. In the, having considered the contentions advanced, we are of the opinion that it is for the petitioner to approach the director and seek appropriate posting orders in accordance with the communication issued to him on 16/1/2024. There will accordingly be a direction that in case the petitioner reports before the director on
A
Monday
week after,
Tuesday or Wednesday, my lord.
or maybe the,
a week, I have to communicate, my lords, a little bit leverage. my lords.
yes,
Ninth, my lords,
9th.
9th at 3 PM, my lords.
On 9/8/2024 at 3 PM, the director shall look into the requests of the petitioner and take appropriate steps for granting posting orders in accordance with law.
My lords, what happens is one clarification, because it's procedural in nature. First, the director has to condone the leave and then it has to be referred to counseling for posting, my lords. It's a two-step issue.
shall take appropriate steps in accordance with law for
That's,
granting posting orders. Yes, whatever is necessary, you can do. Can we dispose it off?
that's the reason I suggested
Yeah,
it.
have it on.
It
After
can be
posting, your
disposed of.
lordship may dispose of, my lord.
Liberty that if audience not given, let him approach this honorable court.
Not with regard to audience, my lord. Let them permit me to report for duty and thereafter it may be
Sit on
disposed.
someday. But
After
more,
4 weeks, man.
yes. Yes, list it after 2 or 3 weeks. So in the meanwhile, it would be done. On that
Please,
date,
my
let
lord.
us hope that we can
Please, my
dispose it off.
My lords.
Asking him to come again
My lords, agreed.
for a posting may be too much.
Sorry for passing on such annexes, my lords. I received it through WhatsApp. I couldn't give a better copy as such. Thank you.
Serial number 28. Is the government advocate ready? The
My lords,
previous matter.
The
item
matter
number
was
28.
argued, my lords, before your lordships. It's where, my lords, I was appointed to my lords school teaching for teaching 8th standard students. Then I sought my lords for appointment in high school, requested for permission to write the exams. My lord, that was not, my lords, nothing was done. I tried several times, my lords.
Concerned counsel who was arguing. the
I
matter.
understand, my lords. My lord, my lords, on the previous day, my lord, your lordships, my lords posed me a question, my lords, about the relevant provision. My lords, I'm sorry, my lords, in fact, that issue is, my lords, there in the rules itself. General recruitment rules, my lords, clearly say, my lords, sub-rule 4, my lords,
Just a moment, it's only
please.
if the government is ready with the matter that we
Please.
need to go any further.
28.
I'll be ready next week, my lords. This allocation is done to me. So I'll be.
With
Not the
that,
difficulty is, my lords,
have these piecemeal arguments.
I know, but what is happening is, my lord, though matter was listed after, my lord, the matter was heard, it did not reach, my lords, the sorry.
We cannot list it for further hearing.
No, I understand that.
It'll, it's be.
Or let it be, my lords, in the orders, my lords, so that
Orders a preliminary hearing or wherever you want.
preliminary hearing, my lords.
Yes,
My lords, I'll try to answer this, my lord. Short issue. I could just recollect the same. Let him argue, my lords, because only is with regard, I'll just say, my lords. What has happened is in certain services, when they are in service to write a qualifying examination to a different post, what happens is we give the permission as such.
yes.
In the present case, we did not, they though asked, we didn't give the permission because it was in the functioning as a teacher. Now there is a higher cadre teacher for which the petitioner wanted to write the exams as such. But the petitioner went ahead and did write the exams as such, my lords. And she eventually got selected to the said post also. So to reporting to the said post, she tendered a resignation as such. So when a resignation is tendered, what the government says is Rule 252 of the KCSR rules are applicable, wherein there is forfeiture of earlier benefits as such. That's the only contention of the government.
If it is to take up another appointment, which is also liable for pension, then it is it?
Liable for pension for that category, there is no list as such, my lords. Now the claim of the petitioner after 15 years of service into the other post would be, give me the benefits of my earlier services for which I have tendered resignation.
My lords, I,
Technically, it is not a resignation at all.
It is a resignation because we have produced the resignation letter.
Producing the resignation, if it is a resignation to take up,
Examination.
no, take up another post in the government itself, which also counts for pension. Technically, the rule itself, if I'm not mistaken, I think it is there in your rule also. It is there in the FR, it is there in other, for, if it is for taking up a post, well, the question would be with the permission of the government. Then it is not resignation. And
My
therefore the earlier.
My lords, the only differentiation what's been done on parity, my lords, may hold it otherwise, I'm being fair to the court as such. What the government has did is in certain cases, they have given the permission. Like that's what the petitioner relies upon. When the permission is given and the examination is taken and subject to such taking up of examination, if the selection is made, the benefit of earlier services is given, my lords. Here, the permission was requested but not given. But still the examination was taken. To take the benefit of the qualification in the other examination, the petitioner chose to resign from the existing post and report it to the new post. So the only thin line differentiation what the government is making is, if we give the permission, we'll give you the benefit of earlier services.
Correct.
If our permission is awaited and still you go ahead and write the examination, getting qualified, you choose to resign. We would invoke Rule 252 of KCSR rules and do not give the benefit of the past services.
What does the provision say?
252 of KCSR rules, my lord.
My lords,
Yes.
he is reading, my lords, 252A, my lords,
Yes,
but not, my lords, 252B.
yes.
My
I'm
lords,
placing the content as
I
such.
understand, my lords. 252B, my lords, there is another provision and my lords which is required to be
Both
considered.
may be looked into is what
Both-
my submission is.
252B, my lords, I relied upon.
Hmm.
Resignation of an appointment to take up with proper permission another appointment, whether permanent or temporary service, in which counts in full or in part, is not a resignation in public service. My lord, the other contention, my lord, the contention which was raised was that, my lords, for writing the exams also I have to take the permission. And your lordships, my lords.
Just a moment.
please.
Your contention is that you have taken up the appointment with proper permission.
My lords, yes, my lords, I would show. My lords, before that, if your lordships kindly take, my lord, the general recruitment rules, my lords. Rule 5, my lords. My lord, this, my lords, I could not show, my lords, during the earlier convention, my lords, round. Rule 5(4), my lords, of the general recruitment rules.
Yes.
No government servant or a person employed under the state government or central government or an establishment in public sector shall be eligible for appointment to a post in any civil services of the state unless he obtains or is deemed to have obtained a no objection certificate in accordance with Rule 11. Soon after his selection, he is notified but before an order of appointment is issued to him and presents the same to the competent authority to appoint to such post. So what is required is after selection, not, my lords, for writing the exam. My lord, the contention which
And
was raised, my lords,
This is done.
my lord, my contention is that, my lord,
Be done without which you would not get the.
my lord,
second appointment.
little bit, Mr. Lord. In fact, my lords, I repeatedly asked for permission to write the exams. It was not given, my lords, admittedly. The other contention is I have tendered resignation, my lords, that is accepted. I'm afraid, my lords, though I tendered resignation is not accepted. But I was relieved in order to, my lords, go and join the duties.
There is no formal acceptance of the resignation.
There is no acceptance at all. There is, my lords, I have been relieved, my lords, of my duties, saying that you can go and report at your risk. That is what, my lord, the authority has said. Now, before my lords, getting, my lords, reported, my lords, in the appointed place, I take the permission, my lord, that is given by the DDPA. My lords, I go and join. My lord, there is no infraction of any rule, my lords, for that. My lords, the submission insofar as, my lord, they said I have approached so many years afterwards and all that, my lords, I made a submission. That I'm repeatedly making the request. In fact, they were, my lord, the concerned DD, my lords, was also asked me to send the records. Nothing is sent. Now, my lords, fresh stand is, or new stand is taken that since I have resigned, all the services have been forfeited. No endorsement, my lords, no consideration, nothing is informed to me, my lords, till this day. This is the stand which is being taken, my lords, before this honorable court. As such, my lord, is not correct. My lords, I may point out, my lord, the permission which is granted. My lords, Anik, page number 59, my lord, sorry, that is in Kannada. But it doesn't say, my lords, the resignation is accepted. But the authority says, as I made a request for being relieved, in pursuance of the appointment taken, I am relieved on the conditions, my lords, is the order. Page number 59, my lords, order at Annexure 8. He says both are equal posts. My lord, the first condition is since both are equal posts, the permission is not given from this office. As till date, her probationary period is not over and she has made the application for taking the exam.
the permission is given at her own risk. Second is, my lord, she should abide by the directions issued from the government and the courts which will be issued from time to time. And she cannot consider her past services as a matter of right. My lords, I'm only seeking for, my lords, what is available under the rules, saying that you consider that for the purpose of qualifying services and nothing else. I'm not saying, my lords, that should be considered for benefits or whatever, except for, my lords, counting of service. That is, my lords, what is provided, my lords, under the rules also. 252B, my lords, is the provision. It says even if it is a resignation which is tendered, accepted for joining the higher post, it will not count as resignation.
Proper permission is what the language is being used.
Another appointment, not the exams.
Permission to take up another appointment.
My lords,
Not for the exam,
one thinking of the government, why we say that a proper permission, if my lordship could discuss that rationale, lords. Because already a certain post, certain school, the working would be happening, my lords. So we in our wisdom give the permission to take up an examination for a similarly situated post or not, seeing the functioning of the school in which the applicant would be working, my lords. That might be the thinking of the government, wherein we insist that you take a permission, proper permission for taking up the new avenue, what is available to you, my lords. That is one proposition what I would like to place before this. Because a vacuum will be created upon resignation in the post in which the petitioner would be working as such.
Where is the provision which says that for the examination, permission is required?
Examination, that I have to look up, my lords. I just.
Says only resignation of an appointment to take up with proper permission another appointment. Therefore, the permission is for the appointment.
If the permission is held back, in the sense there is no communication as such, whether it was denied or rather.
No, that is for the examination. For the appointment, there is permission. Because without there being your no objection certificate, he could not have, he or she.
I stand corrected, my lords. Yeah, this is my reading of, I stand corrected. It's another appointment. So once we give the permission, we are stopped, is my lordship's thinking as such. I was going to even prior to taking up the appointment.
If as a matter of fact, there is a requirement that for.
I stand corrected, my lords, because the premise on which I made this submission is, I was on the yardstick that for writing the examination itself, permission is there. Here, because for the appointment, the state has given the permission, but conditions were imposed.
Condition says it is at his own risk. Therefore, it will have to comply with the rules. The rule says that it is not a resignation if it is with proper permission. Therefore, there is permission.
So my lordships the thinking of the court would be, though we have not accorded permission to writing of the exams, our later act of giving the petitioner permission to take up the appointment would be sufficient to grant them the.
He can't simply.
Agreed, my lords. I am just.
Simply give a resignation, go and join somewhere and say that I'm entitled.
We have acted and we have given the permission. That act would bring about 252 subclause B is this court's thinking as such is.
I haven't seen any provision which says that for in some cases, the rules would say for applying for any other appointment, you require permission. Applying for appointment.
Only on that aspect, that minor aspect, 230, I'll come back. If I can find something, I'll just clarify.
Please.
Even if there is such a provision, won't 252B override that? Because once you give.
If that's the thinking of the court, my lordships may proceed. I'll just try to see.
We don't want to do anything without seeing the.
I'll just see if that with regard to writing of the examination, anything I could pull out.
Even my submission is based on the general recruitment rules, which says for
Correct,
appointment
correct.
only have to.
Correct. Appointment, they'll need no objection. It is because that will have to be produced here. Failing which it would not have.
I'll see if I could just bring
Please,
out anything. Lords, from 30 to 34, there's a handicap today. Sorry, man.
A very short point is involved, my lord.
A little
Though, my lord, I
perspective.
was promoted to the post of assistant executive engineer and executive engineer officiating basis. Lords, the increments I'm entitled, my lord, that has been denied by the authorities.
Why, on what ground?
Let's say that the observation of the tribunal is very specific on that point, my lord. Now, my lord, they say that I'm not entitled for the additional increments on acquiring the promotions also.
Hey, what is the reason they say?
Lord, reasons assigned is, Lord, promotions are granted retrospective, but I'm not entitled for the pay retrospectively.
My lords, it's the state's petition, my lords.
It's a state's petition. Lord.
We'll have it on.
Some date may be fixed, my lord. Otherwise, my lord, I'm retired in 2019 itself.
This is not mine. When can we list this?
Next week, Wednesday, any date,
Please,
Wednesday is too full now.
whatever the.
very well. Grateful.
30, 31, 32, 33, 34.
31, my lord. Matter pertains to transfer. During the pendency, the petitioner has retired from service, my lord. This petition may not survive.
It is submitted by the learned counsel for the petitioner that the issue raised in this petition is with regard to transfer, and that the petitioner has retired from service.
On 31/5/2024.
31/5/2024.
Please.
The writ petition is therefore closed as infructuous.
Yes.
Let's appeal for the petition. My lords heard the matter on last occasion and directed me to
Another combination.
directed me to place some document to show that when you have applied for the driving license, my lords, driver mechanic post, my lords. I have obtained from the RTO office. My lords. Put it, sir.
Did you apply?
My lords, on well before the issuance of notification, my lords, on 16/6/2020, I applied for the 16/6/2020, my lords.
16/6.
Yes, my lords. Notification is dated 18/6, my lords. The entire period is in COVID lockdown, my lords.
Which is the provision in the Motor Vehicles Act,
Yes, my lords.
which says that it will be
Under Rule 15, my lords,
of
he has to wait for 30 days to get the driving license, my lords.
Rule 15 of
I have stated in my memo, my lords. Central Motor Vehicle Rules 1989. Central Motor Vehicle Rules 1989.
What's that? Once you make the application that it will be deemed to be in
Rule 15, driving test.
Hmm.
No person shall appear for the test of competence to drive unless he had held a learner license for a period of at least 30 days.
So when did you have a learner's
My lord,
license?
16/6, he obtained the learner's license.
You obtained.
Yes, my lord. I placed it along with the memo, my lords. Second document is the learner's license, my lords. Till 22/7, the lockdown was imposed by the state government.
16/6 you obtained the learner's license.
Yes, my lords.
You cannot make an application for a driving license till
16/7.
16/7.
Yes, my lords. Till 22/7 lockdown. Till 22/7.
Then when did you make the
On
application?
23rd, I obtained the driving license, my lords, after lifting the lockdown.
How can that be?
Till 22/7/2020, there is a lockdown. On 23, the RTO office has been opened. I appear for the driving test and they have issued with the driving license minutes.
23/7.
Yes. And 23/7, second notification issued by the government by extending the cutoff date to 27/7/2020.
Something which needs consideration.
Yes,
I'll look
please.
into and make this up.
Please, because.
That is the only.
Because in the lockdown period, he gets the eligibility. Post the lifting of the lockdown, on the very next day, he gets the DL minutes. I'll look into and make the submissions as such.
Yes. Sit on some other day. Then Gunpleader seeks time to get instructions list. 22nd.
On the memo file minutes, instructions.
Yes, on the instructions on the memo filed and the documents produced there.
Great.
33 and 34, I am requesting for passover, my lord. This is a fresh matter. There is no interim order. That's my difficulty, my lord.
We'll take notice, my lords, if there's no entry.
Yes.
No, my lord. It was heard by your lordships and your lordships was inclined to grant interim order. It was directed them to take instruction, my lord.
Can this come on Tuesday?
There is no interim order, my lord. Matter pertains to suspension, my lord.
Then let it come on Tuesday.
I'll take a chance, my lord, in the afternoon.
I'll see what best I can do.
Yes.
Great.
Pass on.
34 also, my lord. Please, my lord.
No, 4372.
Here for the petitioner considering this matter. And the other matter, connected matter, here for the respondent. Applications were called for selection in respect of certain posts. Instead of filling out from the general category, which was to be filled up by general category, these candidates were accommodated in that. The present petitioner and others, another 4 persons, together challenged it in by filing application before the Karnataka Administrative Tribunal. By the order at Annexion A, page 67, the applications were dismissed. Unfortunately, the present petitioner did not pursue the proceedings further by filing the writ petition before the High Court. In the meanwhile, other persons filed the writ petition challenging the order. The lordships would find that order at page 281.
Yes.
The writ petitions were allowed. On merits, it was held that those vacancies could not have been filled up by the in-service candidates, that was wrong. Ultimately, there was a direction that the petitioners will have to be appointed to the regular post to which they were eligible but were overlooked. But it was directed that the other persons who were in-service candidates who were accommodated, that is page 332, they were being in-service candidates, they had little service left or some years left. Therefore, a direction was issued that a supernumerary post may be made and they may be accommodated there in view of this. I'll read that operative portion. Page 331, conclusion starts. For the reasons aforesaid, we cannot subscribe to the judgment of the tribunal impugned here. Order dated so and so deserves to be set aside insofar as the petitioners are concerned. The final selection list dated 3/1/2012, though cannot be approved insofar as the selection of private respondents 3 to 21 under the open competition category, having regard to the appointments made and such private respondents working in the said post for a long period, disturbing them at this length of time would only cause great hardship, prejudicing their rights to appear for such competitive examinations having regard to the age factor, but would disturb their merit in the selection under service category. In order to balance the scale of equity and to meet the ends of justice, sans disturbing the selection of private respondents, we direct that official respondents, KPSC and the state government to consider the case of the petitioners for selection in the open competition category and if found eligible and entitled, accommodate them in the vacant sanctioned posts, if any. If such sanctioned posts are not available, supernumerary posts shall be created to accommodate them. However, they shall be placed at the bottom of the selection list. In view of the above so and so, order in application is hereby set aside insofar as the petitioners are concerned. Compliance shall in 4 months. Actually, the application, original application made before the tribunal was ultimately allowed and the appointment was granted. The petitioner, present petitioner, was one of the applicants along with the other 3, but she had not filed the writ petition. Now she has filed the writ petition, of course, after the order.
When was the judgment in the writ petition? Twenty-one, 6/21.
2021.
The OA had, the application had been dismissed when? In Annexure A?
Annexure A, just a minute.
No, the earlier application?
Please, I just.
Annexure A is at page 67, my lords. 23rd of August, 2013.
Twenty-three, 8/13.
Yes.
No, you want the same benefit as has been given to the others in the writ petition which was filed in the year.
Who were petitioners along with me.
Difficult.
Of course, Malad, the delay in latches is one of the things that would be that
Not only delay in latches, senior counsel, the issue of fence sitting. Because when you could have joined them, you chose to wait to see what the result of their litigation would be.
It was not that. all of them were unemployed. It appears she was able to secure a small job in a private firm and was working outside Bangalore. Not a case wherein a fence sitting or she had some other this thing.
She loses her rights to challenge the order by a flux of time. Then somebody else who's diligent, who takes the pains, gets a benefit. Then she comes back and says that I am entitled to the benefit. Fred.
There is one aspect. May kindly see. The present petition is filed.
On 29/10/2022.
2022. Therefore, not that after the order, this thing, but immediately on that it is filed. But adding to this, there is one other development which might make a difference. The other development is another candidate who had not at that stage had approached the administrative tribunal, filed a petition, application before the administrative tribunal, and that application is allowed, which is the subject matter of writ petition by the KPS. That is the connected matter.
If that petition gets allowed, this petition goes.
Yes.
It's
Therefore, the question is this. After having challenged a selection, suffered an order.
I understand, my lord.
Can you sit back?
There's a formidable
problem
point against me, but at the same time, I would point out the order passed in the writ petition 21st June 2021 was on the ground that these vacancies could not have been built up or considered in with the in-service candidate that was totally without authority. That is a point on which if I am able to persuade your lordships to look into that from that perspective, then the order, even if passed in one petition, would become, the benefit would become available to all of us. Though
unless the court specifically limits.
For that also, I am trying to point out if the finding is in-service candidates were not to be considered at all, that was something which could not have been done. If on that point the writ petition is allowed, then it is something which would become available for all. And whether confining it to petitioner could have been in those things could have been made, or even if that is made, whether the benefit would be.
Just a moment. Agreed. If that is your contention, where do you raise it? Can it be in the form of another writ petition, or would it have to be in the writ petition which has been filed? And
of course, as far as first petition is concerned, I will have to come to court challenging the order of the tribunal. Therefore, any contention either this way or that way will have to be put in this. I am bringing to your lordship's notice one decision of the Supreme Court which said, in some of such cases, the courts confining it to petitioner or the order not to treat it as precedent, etc., would not be permissible under Article 226 is how the matter is, court has taken this view. If that could, if I am able to persuade your lordship to consider that aspect with reference to this judgment, and if I am right in saying that if in this judgment the view taken is those vacancies were not available for the in-service candidates, then my lord, I would try to persuade your lordships to consider the lordship may kindly go to page 296.
Yes.
There is no dispute that it's under the same notification, all those things. Therefore, facts narrated that can.
Exactly.
Para 3.
Yes.
Recruitment to the post of assistant executive engineers in public works engineering department is governed by Karnataka Public Works Engineering Department Service Recruitment of Assistant Executive Engineers Division 1 so and so rules. Published in the official gazette on 22/2007. As per the recruitment rules, 75% of the posts were to be filled by promotion of assistant engineers to Division 1, 20% by direct recruitment by open competition, and 5% by direct recruitment from in-service candidates. KPSC issued notification dated 17/4/2007 inviting applications for 52 posts of assistant executive engineers, out of which 42 posts were to be filled by selection of candidates in open competition category and 10 posts from in-service candidates. Subsequently, some more posts were included for recruitment, and one more notification dated 8/8/2007 was issued calling for applications for recruitment to 104 posts in all, out of which 84 were to be filled up by open competition and 20 from in-service candidates. The selection procedure consisted of a written examination and a personality test. As per Rule 8 of the recruitment rules, based on the merit in the written examination, the candidates were required to appear before KPSC for personality test in the ratio of 1:5 in each category of reservation. Provisional select list was published in respect of 84 candidates selected in the open competition on 20th May 2009. Similar provisional list of 20 candidates from in-service candidates was published on the same day. In the meanwhile, there was a dispute regarding applicability of the creamy layer to in-service candidates claiming reservation. The matter attained finality with the decision of the Honorable Court dated 15/12/2010 in WP so and so and connected petitions, wherein it was held that benefit of creamy layer policy was not applicable to the in-service candidates. Thereafter, the revised provisional list was published in 2 separate notifications of event dated 9/12/2011 in respect of open category competition and in-service candidates. After considering the objections, a final selection list of open competition candidates in-service candidates was published in 2 notifications dated 3/1/2012. Though petitioners were selected in the provisional list and participated in the interviews in respect of open competition category, their names did not figure in the final selection list dated 3/1/2012. It is the grievance of the petitioners that KPSC has selected 39 in-service candidates as against 20 posts stipulated in for in-service category notified in the recruitment notification worked out on the basis of recruitment rules. Albeit, those in-service candidates had claimed consideration of their candidature only in service quota. Instead of considering 84 candidates from open competition, KPSC restricted the selection to 65 and selected 39 candidates from in-service category. The in-service candidates who have been selected in the open competition quota themselves had indicated in their application that they have opted their candidature in service quota only and not in open competition quota. But while finalizing the select list, 39 candidates have been selected from in-service quota, thereby reducing the number of candidates to 65, thus affecting the rights of open competition category candidates. The petitioners have no grievance about the selection of in-service candidates within their quota, but their objection is to selection of more service candidates in the quota meant for open competition candidates, hence being aggrieved by the final selection list insofar as it relates to selection of private respondents, filed the applications before the tribunal which came to be dismissed. So and so, representing the petitioner submits that recruitment rules contemplate 75% of the posts to be filled by promotion, 20% by direct recruitment from open competition, 5% by direct recruitment of in-service candidates. If such specified percentage of posts is allocated to different categories, the selection contrary to the same would be in violation of recruitment rules. In-service candidates have no right to state claim against 84 vacancies set apart for open competition and inclusion of in-service candidates in the selection list relating to open competition quota is bad in law. Referring to column 7 in the application form prescribed by KPSC, submitted that column requires an in-service candidate to indicate whether the candidate to be considered for in-service quota or not. The tribunal ought to have considered this vital aspect in right perspective while adjudicating upon the matter. Filling up the vacancies over and above the number of vacancies advertised is violative of Article 14 and 16 of the law. The tribunal committed an error in not noticing this fundamental aspect. The change in the norms of recruitment during the pendency of the selection process to the disadvantage of the candidates who were denied opportunity is impermissible. Though provisional selection was based on the quota rule, surprisingly, while issuing the final selection list, the rule and the recruitment notifications are given a go by KPSC. The tribunal ought to have considered the relaxation of condition in advertisement as per recruitment notification made at a belated stage without re-advertising the post. However, the tribunal failed to notice that private respondents who clearly opted their candidatures to be considered in the in-service candidates quota were called for interview in that particular quota, but finally selected under the open competition quota, which has contravened the percentage of posts for recruitment in service and in competition candidates. Any meritorious candidate in open competition quota could not have been deprived of the opportunity of getting selected by reducing the number of posts, from which it can be inferred that it is nothing but favoritism to the in-service candidates, which smacks of arbitrariness. Such action of the KPSC have been considered by the tribunal in right perspective by annulling the selection of private respondents in directing the consideration of the cases of open competition candidates in their place. Learned Council has placed reliance on so and so. Learned on para 6. Learned Council also for the petitioners in WP so and so supporting the arguments of so and so submitted that final selection list is contrary to the basic rules and recruitment notification. Tribunal misdirected itself based on the earlier order of the tribunal in so and so, which with great respect is not in conformity with the law declared by the Honorable Apex Court in Second Petition. There is no justification for KPSC to utilize the post earmarked for open competition candidates for accommodating more number of in-service candidates. Change of policy during the pendency of the selection is impermissible. The tribunal ignored the same while dismissing the application. Shri so-and-so appearing for KPSC submitted that as per the recruitment rules, 75% of posts have to be selected on promotion. For direct recruitment, there were two sources, 20% from open competition category and 5% from in-service category. Apparently, those sources were different. A common application was prescribed for both categories. The question number 7 in the application was prescribed only to ascertain from the candidate as to whether such candidate decides to have his claim to be considered in in-service quota. The same could not prohibit an in-service candidate who had expressed his desire to be considered in the in-service quota from being considered in open competition category. Referring to the government order dated so and so issued by the government of Karnataka regarding the reservation policy under Article 15.4 and 16.4, laying down the comprehensive privilege policy, Learned Council submitted that candidate who was a Group B officer in the service of government is not eligible for reservation under the same category of backward classes. Further, it was submitted as per Rule 11 of the so and so. The government servant applying for an appointment to any service or post is required to submit application through competent authority to appoint him to the post which he holds at the time of making application. The discretion is left to such authority to decide whether government servants could be permitted to apply, and such permission could ordinarily be granted unless the authority considers grant of permission will not be in public interest. All the in-service candidates, private respondents had forwarded their application in accordance with the said rules. Qualifications in the written examination selection process for both sources being same, eligibility of in-service candidates in open category cannot be denied merely for the reason that they have expressed their desire to consider their claim as in-service candidates. Learned Council submitted that there is no absolute bar for considering the reserved candidates in general category, since in-service candidates can also apply in the open competition. In order to select more meritorious candidates from all channels, the candidature of in-service candidates could certainly be considered in the general competition category. Less meritorious candidates are stopped from raising grievance regarding final selection list. The petitioners, having not obtained the required marks even to reach the cutoff marks in each category, are not qualified to challenge the selection. They are in no way prejudiced by the selection of private respondents. It was argued that legal position in as much as in-service candidate could be considered in the open selection category as held by the tribunal in so and so was holding the field for nearly about 28 years. On application of rules of stare decisis, the action of KPSC in considering the candidate of in-service category in open competition and approval of the same by the tribunal cannot be faulted with. Nextly, it was argued that equally significant aspect of this is the non-joinder of necessary parties to the proceeding. All the candidates in the final selection list are required to be arrayed as parties to the proceedings when such selection list is challenged. Apparently, petitioners have not implemented all candidates selected in the final selection list. Further, it was argued that as per Act 1 of 19, so and so, which has come into force on 3594, the selection of in-service candidate in the reserved category as general category candidates on the basis of merit in competitive examination cannot be held to be unsustainable. Learned Council has placed reliance on following agents. Learned Council, para 9, appearing for respondents 23 and 24, submitted that these private respondents have been selected in the open competition category. They were not in service, hence no grievance would have been raised by the petitioners against the selection of these candidates in the open category. Learned Council, appearing for the private respondent, justifying the final selection list and impugned order supporting the argument of KPSC, strongly contended that selection of private respondent is in accordance with law. Learned Council submitted that private respondents are working in the selection post since 2012 and they cannot be disturbed at this length of time. Private respondents being more meritorious, their selection to be upheld. We are given our terms. Adverting to the arguments advanced by Learned Council for the points that arise for consideration are whether a candidate claiming in-service candidate category of selection would be considered for selection in the open competition category in terms of the recruitment rules, whether the impugned order passed by the recruitment rules provide 75% by promotion from the cadre of deputy engineer, 20% by direct recruitment in accordance with KPSC rules, and 5% by direct recruitment from among persons in service belonging to Karnataka Public Works Engineering Department who possess the qualification prescribed for direct recruitment in accordance with the rules. Recruitment notification issued by KPSC dated so and so calling for application for vacant posts of 104, out of which 84 posts from open competition category and 20 posts from in-service category, clearly classifies them the two categories separately. It is in pursuance to the recruitment notification dated so and so. The petitioners as well as private respondent and other candidates have submitted their applications. Clause number 7 in the application reads as follows. Do you claim in-service quota? Yes or no. For PWD employees only, if so, share the appropriate circle. Indisputably, all the private respondents herein have shaded yes circle, and thus they have claimed in-service quota. Now the arguments of the KPSC as well as the private respondents that the claiming of such in-service quota in the application would not preclude to consider their candidature in the open category, whether could be exceeded with the moot point involved in dispatch of matter. It's not in dispute that a common application was prescribed for both open category and the in-service category. Common written test was conducted. However, separate interviews were conducted for both categories. It is also not in dispute that quota was prescribed for in-service candidates in the ratio of 1:5. In the initial stages of notifying the provisional selection list of candidates, quota prescribed under the recruitment rules was strictly adhered to. Petitioners were selected in the provisional select list if the candidature of in-service category was not meted with in the open competition category. At this juncture, a dispute has arisen in as much as applicability of creamy layer to the in-service category, which has reached finality in terms of the order passed in so and so.
Senior counsel, can we, the finding is that the in-service quota could have been.
Would not have been meddled with.
The quota could not have been changed by the selecting authority. And now shall we go to the final conclusions?
Request your lordships to have a look at the para 27 also before.
Yes, yes.
That is at page 329.
Yes.
In this regard, London Council for KPSC has fairly submitted that in the event this court holds that the procedure followed by KPSC in notifying the final selection list is unjustified, the rule of equity has to be applied since the private respondents who were selected in the open competition category, though were meritorious under the in-service category, would be deprived of their rights and benefits to which they were entitled to. In other words, in-service candidates, private respondents selected under open competition category are more meritorious than the candidates selected under the in-service category. In that situation, it would be unreasonable to disturb the final selection list. It would be appropriate if suitable orders would be passed permitting the official respondents to consider the case of the petitioners if found eligible under the sanctioned vacant posts. If such sanctioned vacant posts are not available, to accommodate them by creating supernumerary posts, however, placing them at the bottom of the final selection list. In effect, KPSC tried to make a case that yes, even if it is held as mistake, don't remove those persons, accommodate. For the reasons stated, we cannot subscribe to the judgment of the tribunal included herein. Order dated so and so deserves to be set aside in so far as the petitioners are concerned. This is where the glitch is. In so far as the petitioners are concerned, the final selection list dated so and so, though cannot be approved. In so far as the selection of private respondents 3 to 21 under the open competition category, having regard to the appointments made and such private respondents working in the said post for long period, disturbing them at this length of time would not only cause great hardship, prejudicing their rights to appear for such competitive examinations, having regard to the age factor, but would disturb their merit in the selection list under the in-service category. In order to balance the scale of equity and to meet the ends of justice, sans disturbing the selection of the private respondents, we direct the official respondents, KPSC and the state government consider the case of the petitioners for selection in the open competition category, and if found eligible and entitled, accommodate them in the vacant sanctioned post. If such sanctioned posts are not available, supernumerary posts shall be created to accommodate them. However, they shall be placed at the bottom of the selection list in view of the above so and so. Of course, my lord, both the sentences are available. Court held that selection list cannot be approved. Selection list of so and so in respect of this portal cannot be approved. But at the same time, court has confined it to petitioners.
Can we continue after lunch?
Please.
There's
Lord
one
Mary.
Kalburgi bench matter.
Please.
My lord, may I request, my lord?
Yes,
In other connected matter, my lord, the KPSC has filed a writ petition, my lord.
yes,
That we have challenged the honorable tribunal order in that.
correct.
The same benefit is extended by the tribunal. We have challenged on the two grounds, my lord. I given judgment, my lord, let him read and it may be taken day after tomorrow. I have parted matter in portal number 8. My lord. That is, it's continuously going.
Just because at 2:30 there is a special bench.
We can have it.
Tuesday.
I will,
Be accommodated for about
Lord,
9:30.
if any judgment they are willing, they can give us, Lord, we will be prepared.
Yes,
I will give the judgment I rely.
Tuesday.
Sixth.
Obliged.
Serial number 34, it's a fresh matter, my lord. May I request to take up at 2:30, my lord. Very small matter, suspension.
Today, many instructions are to be secured. Tuesday, my lord.
2:30, there's a Kalburgi matter. There are several matters posted at 2:30 for instructions.
I'll,
Take it up.
yes,
Also have to secure instructions, so I'm.
but
requesting for Tuesday, my lord.
in that, I'll take chance, my lord. I'll wait.
Parked around the world. And when I don't know, I think we should go to the main factory to get it. Hello.
ಎಲ್ಲಿದೆ? ಸ್ವಲ್ಪ ಈ ಸಲಕ್ಕೆ ಹೋಗ್ಬರ್ತೀರ ಕೊಡೋ ಬಿಸಿದ ಈ ಸಲ ಅರ್ಜೆಂಟ್ ಫೋನ್ ಮಾಡ್ಬೋದು. ಹೌದು ಹೌದು. ಹಲೋ ಹಾಗೇನು ಸರ್? ಹಾಗೇನ ಹೋಗಿ ಚೆಕ್ ಮಾಡ್ಕೊಳ್ಳಿ ಸರ್. ಚೆಕ್ ಮಾಡ್ಕೊಳ್ಳಿ ಸರ್ ಆಗಿದೆ. ಆನ್ ಆಗಿದೆ ಸರ್. ಅಲ್ಲ ಅಡ್ವೊಕೇಟ್ ಯಾರು ಇಲ್ಲ ನಮ್ಮ ಪ್ರಾಬ್ಲಮ್ ಅಲ್ಲ ಸರ್. ನಾವಂತೂ ಕನೆಕ್ಟ್ ಮಾಡಿರ್ತೀವಿ ಸರ್. ನಮ್ ನಮ್ಮಂತೆ ಟೋಟಲ್ ಗೀಟ ಎಲ್ಲ ಕರೆಕ್ಟ್ ಮಾಡಿಟ್ಟಿದ್ದೀವಿ ಎರಡನ್ನು. ಅಡ್ವೊಕೇಟ್ ಜೊತೆ ನಮ್ದು ಪ್ರಾಬ್ಲಮ್. ಹಲೋ ಸರ್. ಹಲೋ 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 ಹೇಳಿ ಸರ್. ಕನೆಕ್ಟ್ ಮಾಡಿ ಬಂದಿದ್ದು ಟೋಟಲ್ 6 ನಂತರ ನಾ ಈಗ ಬಂದಿನಿ ಕರೆಕ್ಟ್ ಬಂದಿದ್ದು. ಅಡ್ವೊಕೇಟ್ ಬಂದಿಲ್ಲ ನಾವೇನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ ಸರ್. ನಾವು ಹೇಳಿದ್ವಿ ನಾವು ಎರಡಕ್ಕೂ ಕರೆಕ್ಟ್ ಆಗಿದೆ. ಬೆಂಗಳೂರಿಗೆ ನಮಗೂ ಕರೆಕ್ಟ್ ಆಗಿದೆ. ಅದೇ ಟೋಟಲ್ ಕನೆಕ್ಟ್ ಮಾಡಿ ಏನೋ 1000 ಬಂದಿಲ್ಲ ಅಲ್ಲಿ. ನಾವೇನ್ ಮಾಡಕ್ಕಲ್ಲ ಸರ್. ಹೌದು ಸರ್. ಹಲೋ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಬೆಂಗಳೂರು ಬೆಂಚ್. ಹಲೋ ಕೋರ್ಟ್ ಆಫೀಸರ್. ಕೋರ್ಟ್ ಆಫೀಸರ್ ಬೆಂಗಳೂರು ಬೆಂಚ್. ಯಾರು Sir, court of sir. Court officer, Bangalore bench. Madam. Madam, ಆಡಿಯೋ ಬಲ್ಲ ಮೇಡಮ್ ಕೋಟಲ್ ಕಲಬುರಗಿಯಿಂದ ಮೇಡಮ್ ಸರ್
ಕೇಳಿಸ್ತಾ ಇಲ್ವಾ ಸರ್?
ಹಾ ಮೇಡಮ್ ಈಗ ಕೇಳಿಸ್ತಾ ಇದೆ.
ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
ಹಾ ಮೇಡಮ್.
ಆಡಿಬಲ್ ಇದೆ.
ಹ್ಮ್.
ಅದೇ ಇನ್ನು ಮೇಡಮ್ ಬಂದಿಲ್ಲ.
ಹೌದಾ ಮೇಡಮ್ ಒಂದ್ ಬಿಟ್ಟ ತಕ್ಷಣ ಒಂದು ಫೋನ್ ಆವಡ ಚೇಂಬರ್ ಬಿಟ್ರೆ.
ಅಲ್ಲಿ ಮೋಸ್ಟ್ಲಿ ಚೇಂಬರ್ಗೆ ಮಾಡ್ತಾರೆ ಸರ್, ನಮ್ ಚೇಂಬರ್ ಇಂದ.
ಓಕೆ ಮೇಡಮ್ ಓಕೆ.
ಓಕೆ.
ನೀನ್ ಬೇಡಲ್ಲ
ಅಲ್ಲಿದೊಂದಿದೆ.
ಹಾ ಅದು ಮಾಡ್ತೀನಿ. ಹಲೋ ಬಂದ್ರೆ ಹೋಗ್ಬಿಡ್ರೆ
ಪಾಸ್ ಓವರ್ ಮ್ಯಾಟರ್ಸ್ ತಗೊಂತಾರ. ಫಸ್ಟ್ ಕಲಬುರ್ಗಿ, ಆಮೇಲೆ 230, ಆಮೇಲೆ ಫಸ್ಟ್.
ಎರಡು ಸಿಸ್ಟಮ್ ಆರಾಮ ಸರ್.
ಸರ್ವಿಸ್ ಮ್ಯಾನ್ಯುವಲ್ ಎಲ್ಲ ನನಗೆ ಹೇಳಿದ್ದು, ಅವ್ರದ್ದು ಸರ್ವಿಸ್ ನನ್ನ ಹತ್ರ ಇದೆ. ನಾನು ಅದ್ರಲ್ಲಿ ಅಮೆಂಡ್ಮೆಂಟ್ ಏನಾದ್ರು ಆಗಿದ್ರೆ ನನಗೆ ಅಂತ ಹೇಳಿದ್ರು. ಅದ್ರಲ್ಲಿ ಅಪ್ ಟು ಡೇಟ್ ಇದೆಯಾ? ಸರಿ, ಹಾಗಿದ್ರೆ ಅಷ್ಟೇ ಕೇಳಿದ್ ನಾನು. ಅವ್ರು ಅದಕ್ಕೆ ಆ ಬುಕ್ ನನ್ನ ಹತ್ರನೂ ಇದೆ. ಏನಾರು ಅಮೆಂಡ್ಮೆಂಟ್ಸ್ ಏನಾದ್ರು ಇದೆ ಅಂದ್ರೆ ಅದನ್ನ ಫ್ರೆಶ್ ಅಂತ ನಾನು ಹೇಳಿ. ಹಾ ಹೌದು, ಅಷ್ಟೇ ಬೇಕು. ಹಾ ಓ ಬಂದಿದೆ ನೋಡಿ. ಓಕೆ. ನಮಸ್ತೆ ಸರ್, ಕೋರ್ಟ್ ಆಫೀಸರ್ ಫ್ರಮ್ ಬೆಂಗಳೂರು.
ಓ ನಮಸ್ತೆ ಮೇಡಮ್.
ನಮಸ್ತೆ. ಇನ್ನು ಮೇಡಮ್ ಬರ್ತಾ ಇದ್ದಾರೆ ಸರ್.
ಹೌದಾ?
ಹಾ
Good afternoon.
Good afternoon, madam. You are not visible.
I'm not.
Visible.
You are visible. You are visible. Yes, everybody here says I am.
Pronouncement of judgment, number 1, Prithvi Shemke.
Why am I not visible to him?
Now I.
Yeah, okay.
Now I can.
The petition fails, accordingly dismissed.
Great.
I hope I was audible.
Yes, very much, madam.
Thank you so much, Baba.
Namaste.
Madam.
Dismissed. Yes.
One suspension matter, Monday, some emergency.
Tuesday.
List 1. 230 orders. 35 urgent, 36 Satish K.
It is after the list. How many matters are there? Yes. But I have taken a put a little bit of balm. It's asked them to get the tissues.
Let's, this is that,
This is the culprit. Yes.
let's, this is the matter relating to PWD, Public Works Department, and Waterworks Department bifurcation matter and the engineer seniority issue. Lords, if my lords recollect, in this matter, there was an interim order of stay. The tribunal, my lords, has granted relief beyond what was granted by, sought forth by the applicants. So, my lords, in the state petition, there is an interim order of stay. Thereafter, my lords, there was an allegation that we were making promotions in respect of different cadres. There was an interim order of status quo insofar as promotions is concerned. Then, my lords, all of the original applicants were recruited, my lords, in the cadre of assistant executive engineer, and my lords, they are now in a higher cadre. So we had sought for a modification. The state had sought for a modification, my lords, for making effecting promotions till the cadre of AWE because it would not affect it. So they had also considered it got modified. Now, my lords, matter has to be heard for final disposal. In the meantime, my lords, some private respondents who are aspiring for promotions from the cadre of AWE to executive engineer have filed applications seeking for modification of that order.
Yes.
Insofar as the state's contention is, my lords, all of them are in a higher cadre. So in case it is modified also, it could be subject to, but there was some opposition, my lords, from the original applicants, my lords, which they will, so in case only on that modification, their application, on the last date of hearing when the matter was listed, my lords indicated that either it could be heard for final disposal or only on the applications. But on that day, since because of positive after my lords had posted it today at 2:30 in the orders list, so
Yes.
only on that applications it could be heard, my lords, only for modification. For a short,
Heard on main, because no, hearing on the main and hearing on the application would be the same.
applications,
Hearing on the main is.
The difficulty is this.
Yes, ma'am.
We will probably have to rise it around 4:30 or 4:45 today because there
Oh.
we cannot go beyond 5 o'clock. Just in case the matter is to, I mean,
Matter, it would take some time. I don't think, having regard to the number of us that are in this side. The petition has to be heard on the modification IA.
Application for.
it is only the modification that needs
Yes.
to be heard, it can be.
Yes, yes,
Can
we are
only
ready.
make
We
it
have filed the application. We are ready. We would like to argue on the modification.
lords, they were.
number 1 is for vacating.
Just a moment, senior counsel.
Let it be heard on main is my respective submission also. Because it has come at this stage any number of times.
Correct.
And because
There is
my
no
lords-
agreement, there is no agreement as to whether the interim,
Yeah, yes.
the
that-
modification now sought for can be granted or not.
Yes.
Therefore, we probably have to be,
Lords, in case the matter has to be heard, my lords, on behalf of the state, we have not sought for modification. It's the other private respondents, my lords, who have sought for modification. Lords, may I just also make, may I make the submission?
yes. Yes, please.
Lords, if an observation could be made, my lords, that it shall not come in the way of making in charge arrangements, my lords, that would also suffice with all due respect.
Yes,
In charge arrangements which will be subject to result of the writ petition.
Yes, my lords, because in that event,
Yes.
they would get retrospective from that date.
If
In
ultimately
case
they- yes.
they succeed.
That's.
And administrative inconvenience also they cannot plead.
That I filed an IA for 8 of 2024 for myself impeding as a respondent. But we are all public, we are assistant executive engineers now. We are also eligible for promotion. Now any in-charge agreement is made. Because all the ports which have been mentioned in the PWD, they will be occupied by other irrigation department. But actually, in fact, the assistant engineers and junior engineers who were appointed in Upper Krishna project, and they have been included in the combined seniority list. This court has said they are not entitled for an interim order has been passed. They are not entitled for promotion. Because their selection itself has been quashed by the tribunal. Then the matter went, they filed the writ petition. In the writ petition, at the first instance, a stay order has been granted. We are quashing their selections of consent. And however, much an interim order passed by the division bench saying that they are not eligible for any promotion. Now, now a combined seniority list has been published. We have been, all these engineers were appointed in the UKP. They have been over and above us.
He is also
PWD.
Supreme Court
Therefore,
regularized.
the matter.
He is also irregular appointment. And he is making a grievance about us.
However,
The only question is, in the
however,
meanwhile,
the Supreme Court has protected our seniority, including all monetary benefits with effect of 2003. The Supreme Court has said the absorption rules have been quashed by the Karnataka administrator. It has been upheld by the High Court. Then we went to High Court, also by the Supreme Court. Supreme Court has protected everything. With effect of 2003, we have given all benefits. We have been included in the seniority list in the care of assistant engineers. Then we have been promoted to care of assistant executive engineer division 1. Everything has been given. We are not irregular appointment. In case of the persons who are appointed in UKP, their appointment has been quashed by their absorption have been quashed by the Supreme Court. Then they went to Supreme Court. SLPs have been dismissed. Subsequent an act has been.
have you filed an OA? Have you filed an application? Were you before the tribunal?
No. We have filed an application before the tribunal, including their names in the combined seniority list. That has been quashed by the KAT. That matter has also been listed. Both are required to be held.
Not made them participate. They challenge the seniority list and the aggrieved persons are now, not even a single person is made party. At least in a representative capacity, somebody should have been made as a party.
Representative capacity, persons have been made. We have relied upon the Supreme Court, later judgment of the Supreme Court.
Even
Supreme Court said that
representative also-
representative capacity.
One hour, even that has not been.
Therefore, my country, the matter is required to be heard by us.
Not. Let them make in charge arrangements. Those who are not even parties are coming here and oppose. Yet to be implemented.
That is to say by the government.
Yes.
Therefore,
Understand
Which are your applications? Which are the applications?
Modification IA. Yes, my lord.
IA number 1 of 23.
Or modification
is for
IA.
vacating sale.
Six
IA
for
number
22.
6 of 2024 is for.
IA 6 of 24 for modification.
Chronologically, vacating will have to be heard first.
Not
Vacating. Even chronologically.
Yes.
It will benefit them also. If IA for vacating is heard, it will benefit them also.
There's no question of hearing the IA for vacating. We'll have to hear it on the merits of the matter.
That's my.
Therefore, in the meanwhile, this will not be. interim
They have
order,
already
stand in the way of
one
their
information.
Interim, and in-charge arrangements, which will not.
Yes, that is all. That is all.
Already
that is already.
No,
made.
no.
That is what
That is
I
not
want.
been- No.
They have went up to superintendent.
Just a moment,
engineers.
just a moment, please.
My lord, sir, my lord, I may I make one submission, my lord.
Yes.
On 30th July 2024, this information was not available to me. They have made independent charge arrangements in respect of 86 assistant engineers. State government says here, as if nothing has happened. The same thing.
To AW.
The modification they are seeking is that only.
AW from,
They have already made 86 independent charge
Okay.
arrangements.
Yes.
And they never
Which is
disclose.
being
From
served.
AW to E. That is all.
That means they want every cadre to
No,
be
no,
promoted.
no, only up to E.
So that-
They are interim prayer.
Two orders in this.
Subject
petition.
to-
No, no, what,
You're all before this, you're all before
my lords,
the High
what
Court.
happens is this one.
Yes,
When they are not even entitled to be in the seniority list to the Public Works Department. It is a case where their eligibility to be in the department is to be tested. When their eligibility is not determined yet, giving them on whatever basis, even to sit on the chair, it would be my lords,
Government has to function.
unheard of, because even in the matter of interim order, Supreme Court has taken a consistent view that If a question of eligibility of some person to be in the department is questioned,
Now, till the post of
My
superintendent
lordship,
engineer, it
this-
has been granted by this court. It has been granted.
my lord,
Permissions
that
have been
was
granted for
AE to
Yes.
AWE.
Yes. We've heard the learned counsel appearing on either side. Learned counsel appearing for the,
Independent.
R22. I appear for R22.
for some of the party respondents have placed on record interim applications, which is the
IS 6 of 24.
In-
IS 6 of 24.
in
In WP 23371. 23371 of 23.
placed on record. Interim application seeking modification of the interim order of status quo passed by this court on 26/2/2024 in respect of promotion to the post of status quo in respect of promotion. Full stop. It is submitted by the learned counsel appearing for the applicants in the IA that the dispute raised in these writ petitions is with regard to the applicants before the tribunal in this batch of cases where persons working as executive engineers.
No, superintending engineer and chief engineers.
Executive engineer also. There are executive engineers also.
Join the service, where persons working in the post
They
of
are working as
engineers and above, full stop. It is submitted that the interim orders granted have been modified by order dated
26/3 ಅಲ್ಲ? So 1/4.
have already been modified
Yes, already been modified once.
and it has been made
ಇದು
clear
ಯಾವ date ಅದು?
that
26/4. 26/2.
26/2/24 is the first order. It was modified when?
15/3.
Sometime
15/3. I'm sorry, 15/3.
on 15/3/2024. The order was modified, restricting it to promotions in respect of the engineering cadres of Assistant Executive Engineers, Division 1 and above, full stop. It is submitted that, it is submitted by the applicant to the IA that for promotion to the post of Assistant Executive Engineers to Executive Engineers as well, as at present, there is no dispute pending before this court in this batch of writ petition. And that the modification should be extended to that, to the said promotions as well. The learned counsel appearing for
R22. Impleading applicant.
it is submitted by the learned, however, it is submitted that an impleading petition has been preferred in this writ petition by Assistant Executive Engineers. And therefore
We are
the,
all assistant executive engineer. We are all assistant executive engineers.
yes,
We are the-
by Assistant Executive Engineers.
we are
And
also
therefore the order of modification may not be issued. Full stop. Having considered the contentions advanced and in view of the fact that the applicants before the tribunal are presently working as superintending engineers and above. We are of the
executive
opinion-
engineers and above.
Executive engineers and above. We are of the opinion that the that a further modification can be granted as sought for in IA numbers, can be granted in IAS number 6 of 2020. We therefore order that the official respondents will be free to make charge arrangements in the post of executive engineers, which will be provisional and subject to result of this
Great.
batch of writ petitions.
Supplementary-
It is made clear that the charge arrangements, if any made
Yes, sir.
pursuant to this order, will not confer any rights on the persons who are granted such promotions or charge arrangements,
They shall not claim
claim-
any equity.
to claim any benefit on the basis of such
In such
orders
an-
or arrangements made.
Yes, in such an
List.
event, minutes, the proposed respondents also eligible for promotion, they are also eligible.
Not said anything. It is whatever it is that they are following, let them follow for the purpose of, if you are there in the list,
Well,
well, and-
their minutes, because since they are, their promotion.
you are not even a party as at present.
Still
Counsel.
proposed.
You cannot make these demands. It is on an IEA by a respondent that we are passing orders.
At least we are
Sorry.
also eligible for the promotion.
Lords may granted, my lords may granted date.
For hearing on one date at 2:30, and please don't list the other matters on that day.
28th.
It's 28th.
Please agree on a date and let the court officer know. On
Yes,
that date,
28th,
we'll
no,
try
fine.
not to list too many of the other matters. The
28th.
usual 2:30 matters, we won't list.
Please.
So that
2/8.
28.
2/8. 20th. ರಜಾ
28th.
ಇದ್ದಂಗಿದೆ ಏನೋ 28.
if there is any difficulty, please inform.
Will.
So that it can be on a defined date, so that the other
28th
matters
is-
will try not to
28th
list on
is-
that.
Thirty-seven, Burgesh V. Charity, translation. 37, Burgesh V. Charity.
Only translation? Yes, whatever is required, please make it available.
38, Poonam S. Patil, delay application need to.
Yes. After a week.
39, Ramya H.N.,
Pleading returned with objections. 3711 days. 3,711 days of delay.
My lords,
3,711 days of delay.
it's an old matter, my lords. I'll comply. There is one office objection that is pending. I'll comply.
Yes, 1 week
That's okay.
to comply.
40 urgent, 41, Government Advocate,
Memo for disposal.
Tuesday.
Another day.
21st August. 42, Mallegowda HP,
I can respond.
Your Lordship, I am applying for the petition in this case. Your Lordship.
Steps have to be taken in respect of R3, my lord. Complainant, he was the complainant, my lords, but he was not arrayed as a party before the honorable KAT, my lord.
R3.
R3, my lord, before your lordships.
But he is the sole complainant before Honorable Loka. So therefore I have made him as a respondent number 3. Your Lordship.
Yes, please take, notice is taken.
Notice issued and process. He has not appeared.
process need to be.
You have to pay process.
Yes, Your Lordship.
Please do.
This is the second.
Third time. Yes, do it immediately.
Your Lordship.
Week's time.
43,
My lord, one small indulgence. 41, we are ready, my lords. I'm just a little.
Your Lordship,
41.
41.
Sorry for
Just,
interrupting.
my lords were to take it up.
May I be permitted to take a take? Your Lordship?
41 now.
41.
42.
Yes, Your
Please.
But
pay
41,
process
I am
first.
ready.
Please pay process to take out notice first, counsel.
Please.
Yes,
41, we are ready, my lords. My
41, I am ready, ma'am.
yes. How many are there?
7,
Quite a
7
few.
back. Before final.
Please call.
ready
Will come to this. 43, BVM Adekar,
The matter will be taken up on Monday because of there's only one office objection complex is court fee. Because the server problem, we could not do the court fee. Monday, there's an urgency. Can be taken up
Pay the
Monday?
court fee.
Monday,
Yes.
Your Honor, Monday, Your Lordships.
Objection to be complied with.
Monday, Your Honor.
12,
Yes, next Monday.
There's an attachment warrant. Your lordship, there's an attachment warrant along with police protection. May be taken up on Monday, your lordship. So it's an humble request.
6.
Much obliged.
44, T. Sheshgiri Rao.
For the response in this case, my lords, filed an application for payment of arrears of rent, with respect to which they have filed their objections and have also filed my counter affidavit to that.
The objection.
Is it over?
Much obliged.
Would it be in the next week, my lord? I mean, the
Lord, and
other
they are not
part
paying
and
the
matter
rents and
in
there is
portal
more than a
number
crore
30.
of rupees that is,
They are paying the rent. That is a contention. It is
Yes.
only with regard to some
Electricity.
adjustment,
Only with
No, no, no. Lord,
electricity charges, etc. That,
with respect to that, they have completely misrepresented before this honorable
yes, we'll
court.
have it
Next week, my lord.
No, no.
Tuesday.
Wednesday. Agboda, na?
Let them not take further adjournments on that day.
No, I don't want it.
Yes.
We are in the parted matter. Another-
Here, it may not be possible to take it up also after there are several
Much
parted
obliged.
matters.
48.
What if 5:70 sought an adjournment morning?
45.
What if somebody had sought an adjournment?
Yes, but
2:30 PM.
there was
2:30
PM.
Okay, okay,
Yes, I'm saying.
okay.
I appear for the appellant's counsel in that.
Yes.
I seem to be troubling your.
My lords, I appear for respondent number 2.
I appear for R3, my lord.
I appear for R1, my lord.
I'll just take a minute and explain what has happened.
Yes, R1.
R.
Yes, my lord. Yes, I appear for
We have a
R1, my
full
lord.
house. Let me just take a minute and explain what has happened. The appellant before the court is challenging an order passed by an emergency arbitrator appointed under the Singapore International Commercial Arbitration rules. I initiate arbitration under a loan agreement in respect of a loan that I had advanced to R1. And the consequence of that loan and the manner of repayment was that he would give me shares in R3, who is a subsidiary of R1. R2 is the promoter of R1. There have been some somewhat fast-paced developments, and that's the reason why the submission that was made in the morning was that he is unable to give an undertaking insofar as R1 is concerned, and I'll make good why that is. What had happened was, in an unconnected matter, BCCI had filed a petition for insolvency against R1 company, that is Think and Learn, and that petition came to be admitted. As it so happens, I appeared for BCCI in that matter, but it's got nothing to do with this. Against that admission order, first respondent has preferred an appeal before the National Company Law Appellate Tribunal. As we speak, orders are being passed in the NCLAT, where there is a settlement apparently that's been reached between BCCI and R1 company. Now, if there had been an admission order and that was the end of the matter, this court strictly can't proceed in the matter because of the moratorium under Section 14. But it appears that a settlement has been reached and the NCLAT should be passing orders. In fact, as we speak, the dictation is going on.
The order is being dictated as we speak.
That's precisely what I said. Now, my submission is this. Our grievance here is that there were certain shares we were promised to the extent of 8.25% of the shareholding of R3 by R1 and R2. We want that secured, subject to the outcome or pending outcome of the arbitration before the Singapore International Arbitration Center. During the pendency of, now the way the SIAC operates is that they don't appoint the tribunal upfront, they appoint an emergency arbitrator, but the concept of an emergency arbitrator has been blessed by the Supreme Court in the Amazon judgment. So there's no difficulty about that. Now, the emergency arbitrator, when the emergency arbitration application was being considered, the first and second respondents gave an undertaking that they will not deal with the subject shares. During the hearing, now after the hearing, the emergency arbitrator grants our relief insofar as 6.5% of the shareholding, but declines insofar as 2%. But what I had asked for was the transfer of the 8.5% to me. So even insofar as that 6.5%, to that extent, I'm on appeal, but that's on the main matter. When this matter was moved before the vacation bench, R1 and R2 at that point represented by one counsel made a submission that they give an undertaking, and I'll just point the court to the order of 2/5/24, where they say that their counsel said that they allay fears of precipitation and on instructions say that they will not take precipitative action insofar as the appellant's claim to, I stand corrected, it's 8.25% of the shares, not 8.5, in R3. Now, today we ask for that to be continued.
The difficulty that they face is that there is an admission order against R1. My submission is that in all likelihood, it is likely that the NCLAT today will either suspend that order of admission or set it aside, but I don't want to be in speculation. Could I make this request? Could the court consider this? Insofar as R2, my learned friend has very fairly said that he'll extend the undertaking, no difficulty. But really what we want is that undertaking to continue in qua R1. Could the court please consider this? Please direct that the order or undertaking be extended, subject to the orders of the NCLAT. That's all I'm seeking. Because if the NCLAT says one way or another, that would. Suppose the NCLAT says no admission shall continue, obviously the undertaking does not.
Yes.
That's
my lord, I appear, my lord, my difficulty is this, my lord, I appear for the IRP of R1, my lord. I don't appear for the erstwhile management because the company is in CIRP. As my learned friend rightly pointed out, my lords, the orders are being dictated as we speak.
Yes.
My lords, my role
Please
itself
make that
will
an
be
order of the court. That's
my lord, yes, my
Yes,
lord, my
yes.
only submission, if my lords may consider, my lords may even consider passing it over so that we have clarity, because the NCLAT will the NCLAT's order most likely will be dictated in the next 15-20 minutes.
But
then there will
the
be
court may
clarity
make it
because
subject to the outcome. I don't think.
my
that is-
difficulty, my lords, I don't even have the papers, my lord. So I cannot be bound as an IRP. I can't commit to an undertaking, my lord, that
The
the
learned
predecessor.
counsel or the learned senior counsel appearing for the petitioner as assisted by the learned counsel for the senior counsel appearing for the appellant, and who submits that the order of the undertaking recorded on 2/5/2024 with regard to 8.25% of the shares with the third respondent shall not be precipitated till the next date of hearing may be continued.
I'm sorry, it should be in the third respondent, not with the third. In the
Yes,
third.
in the third respondent.
Great.
May be continued till the next date of hearing. Full stop. The learned counsel for the second respondent submits that the second respondent is willing to extend the undertaking till the next date of hearing. However, it is submitted that the first respondent
Please.
is
Yes.
facing proceedings before the NCLT, and the matter is being considered
By the NCLAT.
by
Yes.
the appellate tribunal
Please.
today. Full stop. In the above view of the matter, the undertaking insofar as the second respondent is concerned, is extended till the next date of hearing. As far as the first respondent is concerned, there'll be a direction not to take any precipitative action insofar as the appellant's claim to 8.25% of the shares in the third respondent is concerned until the next date of hearing, subject of course to orders to be passed, or subject of course to orders to be passed by the NCLAT.
I'm so very grateful.
My
I'm
lords,
so
my
very
submission as the IRP may be recorded, my lords, that my inability to give the undertaking, my
Yes,
lord, because I
yeah, of
appear for
course.
the IRP.
Yes, yes.
No, but that's why it's a court order. That's why it's a court order.
We understand.
Great.
Yes, that will be
That's it.
recorded.
Great.
I appear for the respondent in this matter. No, there's some serious development, my lord. Your lordships had granted an interim order in this matter. Because the commercial court had not granted an interim order, they came up and appealed before your lordship. Your lordship has granted an interim order saying, don't take any steps to destroy the property. Your lordship may kindly see the order that has been passed.
Yes.
Now, my lord, taking that order, what they've done is, they've prevented me from entering into my property. As a matter of fact, I should show your lordships, my lord, I have a video also of that entire incident. I go to my house. They have in their petition specifically stated that I am living in that house. And they produce a photograph showing that it is my house. They take this order and on that basis, my lord, have actually taken wooden logs and my lord, hammered it into the door and not allowing us to enter. The security guards physically push me and throw me out of that property. My lord, lordship, I have this video, my lord. Please see this video. I mean, this is absolutely shocking.
May
my lord.
make-
And
may
I
make
must
one
make one more
submission.
submission. 1 minute.
May
This, my lord, one more submission. We make a request for a copy of the papers. As lawyers, not a request made, please give us a copy of the papers. The response is, it has been sent to your address, we can't give you a copy. Secondly, they say, we have sealed the premises. I want your lordship to see that letter, my lord, which is received now. We have sealed the premises for safety. Not, may I just pass it on?
Before my lords,
Please see this, my lord.
lords, I may just make two submissions. My lords, at the outset, my lords, they filed an application for vacating of the order, my lords, which my lords had passed on 24th. I don't have a copy of it. My lords, having said so, let them serve a copy upon me. And after that, my lords, let them make any submissions. And my lords, if it's only videos, my lords, what they're effectively trying to say is vacate the interim order, I'll go damage the property. My lords, I will submit. My lords, I may show.
But please see this
They have
video, my lord.
my lords,
I
they
have the video of after the order when I go there. I mean, this
my lords,
is.
may make one submission, may make
Yes,
one
the
memo.
order was this.
Yes, my lords.
Respondent should be restrained from causing any damage to the suit schedule properties.
Yes.
The trees, doors and structures
Yes.
till the next date of hearing.
Yes,
That
ma'am.
is all
Yes, my
this
lords.
court had ordered. There is no power in you to prevent
We
any
have
entry,
not prevented, my lords.
any of, anything going beyond this order.
We are not doing so. We are not doing so. I'm stating that, my lords, as an advocate
Will record your
representing.
undertaking?
Yes, my lords, you can record that
No,
undertaking.
one request.
May make one submission, may make.
Please see
this memo
page
first.
number 3 of the memo I filed, a reply from my learned friend. Please see what they've written, my lord. I just handed over a memo to your lordships. Page number 3, para number 6.
No, where's our letter?
The letter, my lord, from my learned friend. Our client states that our client has not misused any court order. The property remains locked for purposes of safety.
The property remains locked for the purpose
Correct.
of safety.
How do they lock it? It's my house.
Because no, my lords, may make the submission. If my lords, that is what, my lords, let them serve a copy. May pass this IA memo, my lords.
Council,
to
this
show.
is, the order is this.
And my lords,
Since
I will
it is
show.
urged that there is threat of destruction of some of the structures in the suit properties, this court is of. the
And she
view
goes
that the
ahead and she distracts.
Respondent should be restrained from causing any damage to the suit schedule properties or the trees, doors, structures till the next date of
My
hearing.
lords, I am making a statement, my lords, across the bar that we have not stopped her. My lords, may pass this one. Allow me to pass this memo, my lords.
What is
Where, we will give you, sir. We have not got the copy, what you passed to them. Where's the copy for them? What is their copy? Our office copy. My lords, may see the photo, my lords. She shattered the window panes.
How do we know who has?
My lords,
How do we know who has? As simple as that. Please see that the orders of the court are complied with.
yes, my lords.
And that-
We will, my lords, we will.
And that you do not go beyond.
We will not do so, my lords.
Yes.
We will not do so, my lords. We let them not
the
break
Learned
open
Senior
anything
Counsel
which is there, my
for
lords.
the,
And let's let them serve a copy of the application, my lords, which
We've
they
served
filed
the
today.
copy. It was served on 29th. my lord.
How, I don't, we have not a
Sent by
copy, not
email.
got.
I'll give a copy. I'll give a
Let them
copy.
give me a
Please
copy.
take another copy.
Yes.
Please see that anything which is filed is copies are served on the other side.
They,
With
that's-
those being
Where's the
served,
commercial appeal?
they have,
there is the appeal. Please
You've
serve
said I
a
won't
copy-
they've
give it
come on
copies.
record now. They've come on record now.
serve a copy of.
We'll
the
serve a
appeal
copy, my
counsel.
lords. We'll
It
serve a
is-
copy.
It is just courtesy between counsel that we are asking you to.
Respondents have not
serve
served us the
copies.
TI copies, my lords. The vacating of TI. We'll serve copies on the other
I
side.
have the email right here. I have the email right here.
I don't know how they're coming without even seeing my pleadings on record. my lords.
I've come because I know what you did there. I've not said anything else in my application. You come and stop.
I don't know what they're saying in the application
Learned
also.
Counsel on either side shall make available copies of the papers and memos filed to the other side. The learned counsel appearing for the appellant submits that there will be no attempt to get over to then the orders granted by this court, and that there'll be no attempt to restrain
Yes, my lord.
the
Into the scheduled
respondent-
properties.
respondent to entering into the suit schedule properties.
Yes, my lords.
Since
So
the injunction is only with regard to causing damage to the suit schedule properties or the trees, doors and structures therein. List on,
That's
But I
it.
had one request.
Any date at the.
Would your lordship appoint a commissioner to allow me to go there? Because when I go there, they are not there, of course. My learned friend's client is not there, but their power of attorney and security guards are there.
they are,
My lords, I am making
don't
a
know, but-
statement. I will not do so, my lord.
If my learned friend says so,
the
my lord,
appellant,
yeah,
appellant or anybody claiming through her will not permit.
yes,
not
But we won't
prevent.
go beyond the the ambit and the scope of the interim order which my lords have granted. to us.
Absolutely.
Grateful,
Yes.
my lords.
List, when do you want it listed?
Lords may have it next week, my lord, because it's a short issue
After,
now.
after a week give up.
12.
12.
12 tax.
Ayyo.
Lord, can I be permitted in the order, my lord, by hand? Lordships may read the order by hand. I'm grateful.
Chaitanya memo. Handle.
My lords, the interim order, my lords, which has been granted. My lords, there's an office objection, my lords, with regard to certified copy of the order, my lords, which has been imputed. That may be over. Yes.
Yes.
They're giving us a copy now, my lords.
But it's still not giving a copy of the appeal.
No, my lords, it's a bulky appeal, my lords. I can just.
Please, please see that copies are served, counsel. Yes.
Forty-seven, Raghavendra ji guys.
Petitioners. My lords, fourth respondent has given up his selection by filing a memo, my lord. That's why I have not taken notice on him.
Just a moment, just a moment. Where is my list? My list has come down. Yes,
My lords, may come to page 24 of the order of the learned tribunal, my lords. What happened is, my lords, I challenge, matter relates to assistant professor of,
you don't want to, R4 is not.
he has
required
given
to
up
be
his
selected.
selection by filing a memo.
Yes,
my lords.
learned counsel for the
I've just sought for mandamus. My
petitioner
apologies.
submits that notice to the fourth respondent is not required to be taken out. The therefore notice is dispensed with at the risk of the petitioner. List on.
My lords, small, my lords, today only it can be disposed of. But
Happy to remember.
I sought for mandamus as per, to publish additional list as per the direction, my lord, as per the rule, my lord. Only that much, not on eligibility, anything else.
It's
What
dispatched.
tribunal?
Week after next, let it come up.
Please get instructions.
We'll get
Yes,
instructions.
learned government
Yeah.
advocate takes notice for the correspondence one and seeks step to get instructions. Yes,
Obliged,
48,
my lords.
Rangnath, yes, Joyce.
waiting service to R3.
49, Gopal Krishnamurthy.
My lord, 48 Lokayukta, my lord. The respondent 3, in fact, is Lokayukta council is there.
Where is the Lokayata council? Is not there.
My lord, I will.
Please serve a copy,
because
counsel.
Normally, Lokayukta
Serve a
comes standing,
copy and
Mr.
show the
Arbitral.
name.
And I have sought for interim order in this case because, my lord, the last
Have you served copy?
Lokayukta, my lord, government order is the main.
Please serve a copy, council.
Yes, next week, my lord, next week.
49, Gopal Krishnamurthy. Translation.
Only translation.
File dispensation application for the time.
Yes, learned counsel for this. You'll submit whatever is required.
Yes.
Submits that translations of relevant documents will be made available at the time of hearing. List on some other day.
22nd August. 50, Satish K.
But day before yesterday, my lord, it was heard for some time.
R2.
R2, my lord. R2 is Lokayukta. But
Not
the
required.
short point is, my lord, the observation note is issued by an officer in the cadre of,
There's no time today.
but
We've
it was
already
heard, my
acknowledged.
lord, for consideration of interim prayer. My learned friend
Comes up for orders, we will be prepared for the orders issue, my lord. So my lords may kindly post it any day, convenient.
But day before yesterday, it was listed, my lord. The bribe in the form of, my lord, Samsung phone.
We'll list it on Wednesday.
But in the admission, my lord,
Yes. List for admission on Wednesday.
51, Prithvi K.
Wasn't bribe. Yes.
But when this I'll not take a long the memo. And also, my lord, I'm fairly confused that what your lordships have pronounced today at 2:30 may have some bearing on this. But my lord, in this fact situation, my lord, your lordships, I might be able to persuade your lordships to take a slightly different. Could your lordship mainly have the memo?
Is this the new-
Memo yesterday.
Yes.
Irrespective of the legal contention, fact would remain. From 21, I've given my service.
Yes, yes.
From 21, in the first column number 1, I've worked for 12 days. Next for 5 months. Next is 29 days. Your lordship will note, all of this is special land acquisition officer, 29 days. Then as under secretary is the only post where I worked for a year and 7 months. Then I'm posted as special land acquisition officer. I worked there for 3 months. When the then incumbent approached the tribunal, there was an 3 days. 3 days. Incumbent approached the tribunal, there was an interim order finally allowed. I was waiting for posting. Then I'm given a posting on 31-1. This is challenged by one Anupama. Then on 3-2, within 3 days, that order is cancelled. But I challenge the order of cancellation. There's an interim order of status quo after the cancellation. Ultimately, for about 4 or 5 months, there is only an order of status quo. I withdraw it. Cancellation order comes into effect. I am given posting to the present post, that is Special Land Acquisition Officer NHAI on 3/7, which is to come into effect from 31/7. On 4/7, that is cancelled. Again, I am rendered without posting. Tribunal takes the view that since the order has not come into effect, it is available for cancellation. Therefore, cancellation is right, it is within their powers.
Yes, what do you say?
Might I point
Do you
out?
have instructions here? This person has to be posted somewhere, given a posting somewhere and permitted to work somewhere. What is this business of posting,
Tuesday finally, my
cancelling,
lords.
calling
Tuesday
back quick?
My colleague had stood up in this matter, my lords. Tuesday, I'll get the instructions. Even if he's not there, I'll go on with the matter.
Might I point? So, even if there is a stay, I'm only speaking from as a respondent. Even if there is a stay, the present respondent will only go back to his earlier place of working, which is at Kunigal. And I will work here. Ultimately, if your lordship were to dismiss it, they'll give me another posting. It is not as if respondent should be rendered without posting. But if there's no interim order, I am rendered without posting, and not for 1 day or 2 days. Kindly have a look at the chart. From 3/2/2024, when there was an order of status quo by the tribunal. My cancellation order, there's an order of status quo. Ultimately, I withdraw it. They give me a posting, and within 1 day, it is cancelled. And somebody who has a posting is given another posting to render me without posting.
Where is the other person brought from?
He is brought from Ramnagaram. May I just draw your lordship's attention to page 53? I have produced that translated copy along with. Page 53.
And that person is now taken charge here?
Yesterday, first month. And even if it is stayed, he'll just go back to Ramnagar. Would your lordship? Part 1 is my cancellation order. Part 2. Mr. So-and-so, KS so-and-so, officer, Special Land Acquisition Officer, National Highway Authority of India, Ramnagar, has been appointed as so-and-so Special Land Acquisition Officer in my place. From Ramnagar, he will come to Kunigal. And even if this is state, he will have a post against his name. He will have a place to draw his salary. He will have a place where he can work his leave from.
If he had taken charge in this post, he would have relinquished the earlier post as such, my lords. We are only asking for few days' time. They themselves say yesterday the charge was taken, my lord. So my lord.
Yesterday itself. And order is passed by the tribunal on 31st.
The hold on the earlier post would have been relinquished, my lords. We will not go beyond Tuesday, my lords.
If he goes back to his earlier post, let him come, let him file his reply. Tuesday, my lords, private respondent will come and say he wants time. And it is not as if, my lords, this is the first time the orders are being cancelled.
We have a genuine reason for asking time for today, my lords. Tuesday, we'll definitely get instructions and make the submissions.
I moved it yesterday, my lord, in the morning, my lord, specifically because
in the
I will
special
make an attempt.
circumstances of this case.
My lords, at 4:40, I'll make an attempt to get instructions if that be so much. If my lords is were to proceed.
The instructions would be that the other person has
Taken
assumed
charge. If my lordships were to stay, the other person will be left without posting.
No,
as such.
he will go back to Ramnagar.
If he has relinquished and another person has sort of taken his place.
Order, kindly see 4-7 order, and your lordship may kindly see the impugned order at least, Annexed A, page 31. Order is passed on 31st July. And it is not the respondent's case, somebody is posted to his case, and if it is quashed, he will be left without posting.
What is the finding with regard to the,
That's the findings would start at page number 37. Para 7.
yes. What is this person, what is the name of the person brought here now? Lokesh.
Lokesh. My lord, the relevant findings would start, my lord, at page number 39. Before
Yes.
that, my lord,
Yes,
at page number 39, the respondent government, second sentence. Page 39.
yes.
The respondent government on the very next day, that is on 4/7, issued the order modifying, cancelling the earlier order dated so and so, and further posted the third respondent as Special Land Acquisition Officer at National Highway Authority of India, Kunigal, so and so. Admittedly, the applicant is still working as COO operation and she has not yet reported for duty as SLAO NHI, as the same will happen only after retirement of one so and so on 31/7. That being the legal position, the applicant has no right over the post, and her right over the post will curtail only after occupying the said place by her on or after the retirement of Srimati so and so. Therefore, the contentions raised by the learned senior counsel for the applicant has no basis, and the decision referred by the applicant has no application. The Honorable Apex Court and so and so has held that the employee has no right over the post. It is for the government to post another employee by modifying, cancelling the order in the interest of public and administrative exigencies. Under these circumstances, there is no sufficient force in the condition.
What was the reason for posting this person here?
My lord, absolutely no reasons, my lord. Let them produce the records on Tuesday, my lord, and your lordship, my lord, but if your lordship were to find any reason in the note sheet, your lordship might dismiss my case right then and there. And within 24 hours, my lord, there possibly could not have been, my lord, a reason where, my lord, when I was brought in, it was in public and administrative interest. When somebody else is replaced, P7, my lord, it's actually the facts which are again called out, para 7.
Yes.
My
Tribunal
request is
has
for
not gone into any of the aspects of the matter.
Then I will leave it to my lordship's discretion.
Heard the learned counsel for the petitioner of the learned government advocate appearing for the respondent. The learned counsel for the petitioner submits that the petitioner has been subject to repeated orders of transfer and is at present left without any posting on account of the cancellation of the order of transfer dated 3/7/2024. It is further submitted that a perusal of the order of the tribunal would show that there were no specific reasons informing the cancellation of the order posting the petitioner as SLAO at NHAI Kunigal on 3/7/2024. In the facts and circumstances of this case, we are of the opinion that the question with regard to cancellation of the order of transfer requires a consideration. Issue notice to the private respondent, list next week. In the meanwhile, there'll be a stay of impugned stay of the order impugned before the tribunal till the next date of hearing.
Great. Deeply approved.
Fifty-two, Narasimharaju.
Represent the state in the matter.
This is also yesterday's matter. This is with regard to these transfers without showing a place of posting.
They have been given posting. What would happen is on 4th, the petitioner would be transferred, but no posting is given. By virtue of another order on 9th, he's been given a posting. May,
When an order of transfer is.
yes, Lords.
What prevents that very same order from giving? a
Lords, we
posting
have
to
also
the
been
other
at,
Because please see your new guidelines.
yes, Lords, they have produced it along with the petition at page
Yes.
number.
Because now in the new guidelines, it appears that the concept of transfer itself is that it must be from one post to another.
Please.
It cannot be otherwise.
Yes, Lords, I do understand.
That bringing a person in to an occupied post
Without giving him.
and the other person, it does not even say that he is transferred.
Please.
It only says that one person is brought in the place of the other. That other person being transferred is not mentioned in the order.
Please, Lord, that is what I
is not
wanted
how
to
it
impress
is.
upon my lords to say that 4th, the order was passed wherein he was no posting was shown. But by virtue of an order on 9th, my lord, such a place was shown.
See, it is-
Yes, Miss.
As a matter of fact, the vacancy should arise before the order.
Yes,
of
my lord, they
transfer.
should have seen to it that the vacancy is there. If not, the transfer couldn't have been affected.
As a matter of fact, you're granting him a posting
Please.
and transferring him out, granting him a posting when his term is about to end.
3.5 months prior to the
Then-
minimum tenure.
Then there would be no
Issue
challenge
of,
at all. There is no
I do
reason
understand.
for a challenge.
I do understand.
And going by your new guidelines, the scope for interference is also narrowed a bit.
Of course, my lord, sir, the entire thing is taken away. The premature transfers, the manner in which we were doing earlier.
That remains to be seen. Anyway, at least
As
it
of now,
has been narrowed down.
please.
So in that sense, if you will first grant posting orders to the person to be moved and then say that another person is brought in that vacant post, it will be the end of the matter.
Please,
This
I
does
do
not
understand.
require this kind of, so much of time is being spent
Spent on transfers.
both by the tribunal and by this court
Please.
on these matters of transfers, which could be so easily avoided
Avoided.
if you would just do it in the
May I just
proper
make
manner.
this submission before my lords? Whoever is the concerned person, I will request my Advocate General also, I will also make efforts to ensure that the mind of the court is being told to them, and we will ensure that in writing also, we will request them not to post anybody without any kind of, transfer anybody without any. Insofar as this case is concerned, my lords, and my colleague is not, unwell today, but my instructions are, my lords had indicated to give an status as to, is there any kind of a criminal case as against anybody, any such thing? My instructions are, so far as the respondent number 2 is concerned, there was an FIR which was filed, but I'm given to understand that the same is quashed
By
with the
this
rider.
court, your lordship, I'm
Regarding
producing
the
the.
sanction, but with the rider that at a future date of point of time, if at all the sanction is given, the prosecution can continue is what the order would indicate.
It stands quashed.
It stands quashed as on today, but with the rider that sanction, if at all, if it is given at a later point of time, it is to continue. My lords may kindly peruse this order. my lord.
I am producing that order, your lordship.
There seems to be a dispute with regarding to who is holding post. What would happen is, on 9th, when we give the petitioner a post, on 8th, there is a status quo order subject to the result of the application. I'm, again, my lords, I'm stating before my lords on instructions that the petitioner has locked the premises and is not giving the cupboard key and other things where the second respondent is unable to discharge his duties is my instructions.
These again are issues which can be avoided. If
I do understand, my lords. Since my lords had
simultaneous
instructed us, I'm
transfers pass, that is the
stating.
end of the matter.
Please, please.
Yes, now where is he being posted?
He is posted as per the 9/7/2024 order,
Hmm.
which my lords would. at
BBMP, Bangalore, my lord.
BBMP in Bangalore only.
My lords, may I see page number 96, my lords?
Hmm.
The translated portion, my lords would find it at 98, my lords. And at serial number 5 at page 99.
Be done after the status code.
No. Fifth, 5/7, it takes the
2740.
reports are due to your lordship. By the time 8th, it was communicated, 9th, the order of posting is given to him. 9/7 is given a posting.
After the status code.
Yes, it is the same person.
Status code is passed on 8/7.
I hear no, sir. 8th ಮಾಡಿದ್ದು 9th.
ಇಲ್ಲ, ನಾನು ರಿಪೋರ್ಟ್ 5/7 ಮಾಡಿದ್ದೀನಿ. ಅದು ಹೇಳಿ.
ಇದು ಯಾರು ಬೇರೆ ಬೇರೆ ಇರ್ತಾರೆ. ಇಲ್ಲೇನ್ ಮಾಡ್ತಾರೆ ಏನು ಪಲ್ಯ ನಮ್ಗೆ
Yes.
But yesterday.
Very state
Stating about another transfer order arising from the same notification. Use that order. I said that that order was not available. But kindly, just take your lordships too. This petition law, 2740 of 24. I wonder if your lordship has this. Yes, in this is not.
Yes.
In this, can we see page 20? 29th of.
Yes.
Yes.
Here, the tribunal says, tribunal and also the Honorable High Court in a number of cases has considered transfers that be effected during general transfers and therefore some relaxation in tenure. One sentence before the previous page.
Yes.
Prior to that, applicant was working from about 5 lines from the bottom.
Hmm.
Subsequently, upon promotion to the cadre of PSC, continued in the same position. Therefore, the tenure required to be considered is that is in 22/11/22, whereas impugned order is 4/7/24. It is undisputed that as of the date of issuance of the order in 4/7/24, general transfers were enforced, and even now it is enforced. Now, the court went by the reasoning that this was a general transfer. Now, kindly consider Shobita's judgment, which I have produced. At page number, this order is passed.
1 minute, number one copy.
Same day, order passed on same day. By the same composition of the
Notification.
and the same notification. In that compilation which I have given, memo.
Yes.
At least in what page number. The reasoning is that. Yes. Page number 24, internal page 12. Now, the only difference is, interestingly, I am SLAO 2, he is SLAO 1. This is the only difference.
Hmm.
At internal page 12, 4 lines from the top. About 8 lines from the top.
Hmm.
I'll start from 3 lines from the top. Applicant was posted in the present place as special adjudication officer, 1. BMR CLK. Correct. Shall I read?
She was there.
While ordered in 6/7/26, she has taken the charge of the post of special adjudication officer 1 BMR CLK. If we take into consideration the date on which the applicant has reported for duty in 7/23, and issuance of impugned order in 4/7/24, it is clear that the said order has been passed before completion of the tenure. Now, this is the yardstick which we have applied. Then it is to be the same whether it is 9 months, 10 months, or 1 year, 4 months, or 1 year, 5 months. On the other hand, the said order has been issued during general transfer period for 2024-25, as could be seen in the order in 4/7/24. The same has been issued by DPR. It was referenced to Honorable Chief Minister, Honorable Chief Minister. The first respondent has issued the order at 4724 by posting the second respondent to the place of the applicant, but there is no transfer or posting to the applicant. As such, the said post is to a non-existing post. Precisely what your lordship said. In the circumstance, it is necessary to learn decisions of the High Court in so and so on. As held, the transfer of government servant to the place. Without there is transfer or posting to that government servant who is working in a non-existing post, such posting is not permissible. Further, the Honorable High Court in the case of Mohammed Zubair was stated that we are mentioning the name in the order and directing the government servant to report before the competent party is not a transfer. And as such order is illegal. That being the question, the order is issued in postings and that is illegal. This aspect is also clear from Seema's case, Pettapa's case, Mehboob Pasha's case. Of course, not covered your lordships many times of this. And we all the sections of the law, but it's clear the order enforcement is contrary to the policy. But very same parameteria facts and circumstances. I've also operated premature. Transfer is operated against me premature. There is no existing vacancy for I am sitting in that post, but on the same set of facts and circumstances for SLA 1, there is one conclusion. I am SLA 2 because I am sure there is a different conclusion perhaps. But not these judgments at variance indicate that the tribunal is not applying the sound principles of law laid down and established by a number of division benches of this honorable court. And once those principles are there, the conclusions cannot vary. That is why I'm not, in Seema's case, this whole issue started with Justice Jayant Patel's judgment, where Honorable Justice Jayant Patel had indicated that while he headed the division bench here, he indicated that unless it is to a post where there is a vacancy, then it cannot be called a transfer at all. Transfer is as against a vacancy. And that is amply indicated in the present circular or guidelines. Can you see the guidelines? I'm sorry, my pains. Reiterating that question. Or two, which are options.
Page number?
Page, internal page 2. No, I had given the official government translation. The government guideline.
Yes.
4.2, which your lordships were pointing out to us. However, while making transfers or deployments, which are ensured no cases arise where government servants remain on compulsory waiting. Here, not even compulsory waiting. Though the one division bench said even compulsory waiting is wrong. Here, not even compulsory waiting. It's just like I'm hired and fired, like in Western countries. One day I'm suddenly fired. In such a way they have operated this transfer. And again, para 5 law. Transfer should not be made beyond the period of general, except that also will not apply. The 661. 6.1. No government servant shall ordinarily be transferred or deployed if he has not completed the period of service. It is very clear that tribunal's understanding was that premature is bad and as against no vacancy, transfer is bad. And tribunal avoided such transfer after arising out of the same notification. So, Lord, it is amply clear that, and moreover, Lord, one issue, interesting issue is 8.7, the tribunal grant status quo. Does the government have jurisdiction at that stage when matter is seized before judicial authority is a constitutional court, because tribunal is a constitutional court? Does the government any longer have a jurisdiction to operate that transfer? Once status quo is there in the face of status quo, a number of judgments where executive fiats versus interim orders. When interim orders are issued, the executive fiats will get stayed. And no executive fiat can alter that interim order. In the system that is there, system of judicial system that is there. Therefore, this executive fiat, which aims to alter the interim order itself, is a nullity. Rightly observed, so Justice Krishna Kumar said. Therefore, from that date, there was status quo. I am there every day in the occupying this position and continue. There was a status quo. They did not raise a contention that they have taken charge, nothing. They have continued. Therefore, on these two sound principles of law, held by a long number of judgments, the transfer must go, the notification must go with respect to me, because it has not indicated the place. Their subsequent post-litem adjustment or trying to give a post is in the teeth of the status quo. They not survive. Therefore, I pray that, and so far as an allegation that there is a criminal charge against me, there is no criminal charge against me because the entire charge sheet have been acquitted in those proceedings.
Has withdrawn the prosecution.
Government
has withdrawn the prosecution.
Yes, government has withdrawn.
Subsequent and not.
Government has withdrawn the prosecution. But not in the recent trend of judgments is a honorable acquittal. That is the recent trend of judgments in Supreme Court. Where there is an honorable acquittal, then the Supreme Court says honorable acquittal in disciplinary proceedings will have a cascading effect on criminal proceedings, and criminal proceedings will lapse. But the acquittal that they have is not a honorable acquittal. Acquittal is on a technical ground. Any time the proceedings may emerge if there is a sanction by the government. Government is yet to consider sanction. That is why they say in that clause 3, it says where it is pending or subsisting, the criminal proceedings. It says government servant against whom there are serious charges and against whom departmental proceedings / criminal proceedings are initiated or pending or prosecution is being contemplated. If it is now the court has remanded the matter saying government has to decide on prosecution, it is in contemplation of prosecution. The formula is ineligible to be posted.
Only one submission, lords, adding to that. Lords, if my lords were to consider, lords, the guidelines, 7, guideline number 7. Lords, under the 7/6/2013 guidelines, lords, the old guidelines, there was a provision, lords, for premature transfer, or even by lords taking the approval of the Honorable Chief Minister. Lords, such a provision, lords, is not provided, lords, under the present transfer guidelines. It only, lords, create certain exceptions, lords, under the guideline number 7. Premature or delayed transfers, the minimum period of service which a government servant may render at a place may be extended or reduced in the following circumstances. Lords, it is only in those circumstances, lords, it could be, lords. Here, lords, the present transfer, lords, does not fall within any of, lords, the exceptions that has been created under guideline number 7. And admittedly, lords, it is a premature transfer, lords. There can't be any, lords, dispute with regard to that. And even the tribunal also, lords, mentions that there is a 3.5 months, lords, of tenure period, which is assured, lords, under the transfer guidelines itself.
Yes.
Lords, except that, my lords, I would only request my lords to see the order of the Honorable Tribunal, page 22.
Yes.
Where the Honorable Tribunal has reiterated what has been stated in the application with respect to a minister having shown inclination to hold this petitioner back in the same place where he is. To say that there is an influence or a thing was brought about to the department by page 22, internal page 3 of the tribunal's order, my lords, in the last portion of the, having satisfied the nature of the work of the applicant, the Honorable Minister of so-and-so issued a letter to the Honorable Chief Minister to continue his service from so-and-so. This only indicates that he wanted to continue beyond his period also.
Yes.
He would also say that certain works which he was doing would be hampered now without because of his transfer.
No, those may not be the, but what do you say about this the very same transfer order.
Well, there is
The
a little
tribunal
difference,
is-
there is a little difference in
What
that,
is it?
Lord. This person who was the applicant Shobita, who was transferred to the post of the second respondent, had only a period of 4 months she has put in. That was the reason why the Honorable Tribunal will hold that since 4 months is extremely premature and then would transfer back and another person is posted on. But then, however, here is the case where he was in the extreme end of his tenure of minimum period. And then the posting, as my lords indicated, yes, my lords, there was a delay of 5 days from 4th to 9th. In respect of this taking over charge, they have an internal dispute as to who was given charge on what day and what not. With respect to the orders of the Honorable Tribunal to continue the status quo would have to be interpreted in the way as to who is holding the post as on that day. The CTC is a self-assumed CTC rather than the applicant giving charge to the second respondent. But on a self-assumption, he says that I have taken charge. Now, what is to be taken into consideration is for my lords to see, my lords. The applicant would say that, no, I have not.
Something which can be easily rectified. You're saying that this court must.
The reason is this, my lords. Both are officers who are posted in Bangalore. I do understand if the situation was there, 2 different districts or which was far away from their native residences, both in Bangalore. But still they would want to only be in the post which they have been given to. They do not want to go to a new place. And now they say that one person, my instructions are, he's locked the cupboard and other things and he doesn't want to. The applicant. I'm only stating on instructions.
Have directed status quo. Yesterday evening, he is trying, despite the direction of status quo, even before it was uploaded, he is trying to change the status quo by trying to barge. That's unfair. He's never been in that
The
position.
question of unfairness would come only if somebody is going other way, my lords. My instructions from the department is that this is what has happened. Subsequent to the order of status quo on 8th, my lords, the second respondent would indicate that he goes and takes charge. And
Subsequent to the order of status quo.
No, prior. I meant to say prior. I'm sorry. Prior, my lords. And the allegation is that in spite of the status quo, he is trying to now take over the chair as such.
In fact, government gave me another position after the status quo. Is an indication that they want the status quo to be altered.
That is not
They
the,
want me to go there and pay way for him.
may I make a submission, Your Lordship? Your Lordship will kindly see, 8/7/2024, I have gone and I have taken a charge. I will get Your Lordship at page 83, Your Lordship.
Of
No, the petition.
He has never been in that position.
which one? Which petition?
740.
2074.
Page number?
Page number 83, Your Lordship.
Yes.
I make a submission, Your Lordship. Earlier, I was working in the National Highways in Mysore. I was transferred here, Your Lordship. On 5/7/2024, I take a charge.
Page 82, my lord should find the signature. 83, the translated copy, it doesn't have the signature.
In the petition.
Just Lord, I'll just to answer this. Just producing the attendance certificate of SLO2. That is why the government is saying.
We are going to such extents in a transfer matter.
This is blurred. Kindly see the date for the month of July at the top. It's in Kannada. Justice, Honorable Justice Basuraj can guide your lordships. This Shivkumar is at the top. I have signed, till 31st I have signed the attendance. On 31st, he also comes and signs the attendance register. How can he, without handing over charge, come and sign the attendance register? And he says, because of KT order, I am signing the attendance register. KT order, if KT order itself per se could grant him the green signal to sign the register. That shows that they have not taken charge. How could I have signed every day? He has not signed one day. From.
No, 5/7, you get the attendance, of 5/7.
Signed one day.
Just a moment, just a moment.
Sorry.
ನಾನು ಹೇಳಿದೆ attendance ಇಷ್ಟು ಅದು ಕಂಟಿನ್ಯೂಸ್ ಆಗಿ ತರಿಸ್ಬೋದಾಗ
ಬ್ಲಾಕ್ ಹಾಕೊಂಡು ಹೋದ್ರೆ ಎಲ್ಲಿ ಸಿಗುತ್ತೆ? He says that he has taken side load express, even recorded in the interim order. He has not signed even after that.
May I draw your lordship?
There it reveals from 8/7, if he has really taken charge on 5/7, his signature should have been there from 5/7 to 31/7. But he has not signed. Then he says by virtue of KIT order, for the first time, he signs the adjudication. This shows that he has not taken charge of it.
That all that happened because he locked the entire office as far as our office is
He
concerned.
locked his entire office.
Your lordship will kindly say.
How can I be present and lock the office?
Your lordship will kindly say, it is a big building, I can, your lordship, I have not completed my submissions. Your lordship may kindly take page number 47.
Yes.
47.
Yes.
I read at page 48, translation, your lordship. Shri S.M. Shivakumar, K.S., CPA Officer, General Manager, Karnataka State Tourism Development Corporation Limited, Bangalore, has been appointed as Special Land Acquisition Officer to KIDB in public and administrative interest until further orders. Why I am reading this, your lordship? Before he has transferred as Special Land Acquisition Officer, he was working as the Assistant Commissioner of the Tourism in Bangalore only. This fact I am emphasizing before your lordship. I am placing a division bench decision of this court. They say, if a person works in the same place, a premature transfer short of term, that should be not to be considered as a premature transfer. I am. Your lordship may kindly take the division bench decision. I am placing before your lordship, page to page. Your lordship may kindly take internal page 5, your lordship. Internal page 5, your lordship.
Yes.
However, in the present case, certain facts are to be kept in mind before proceeding further. The records clearly reveal that the petitioner has been working in a different post only in Mandya city since more than 9 years, that too in the same department, different post. In such a cases, premature transfer cannot be taken into consideration. And another division bench decision of this court, your lordship. Copy this. Internal page 9, your lordship. Internal page 9, your lordship.
Yes.
I read from the 4th line, your lordship. So from the date of appointment till today, he has been working in one or the other place, office situated at a Kolar only, and he has never gone out of Kolar since the date of his appointment. Further, under the present transfer order, he is transferred from the office of the DDPI Kolar to the Government High School Madurai in Kolar. Thus, he is transferred from Kolar town to a village Madur situated within the Kolar. As per the latest government order dated so-and-so, related to transfer of a government official, minimum period of stay in respect of say officials 2 years. Even that is taken into consideration. The applicant was transferred from the Office of District Training Institute, Kolar, to Office of DDPI, Kolar on 8/2/2013, and he worked till now. By the time the present transfer was made, which is yet to be given effect, he has completed 2 years. Then now, Your Lordship, I request Your Lordship to come to the tribunal order. Your Lordship, I may come to the order of the tribunal at page 31, Your Lordship.
Yes.
31, Your Lordship. I am reading for last paragraph, Your Lordship. That being the position, the contention raised by the applicant that is a premature transfer in the absence of arbitrariness is without any substance. The learned counsel for the respondent have specifically contended that earlier also the applicant was in Bangalore itself, and thereafter is worked as SLO2 now. Also is posted in Bangalore alone, and therefore he cannot complain regarding the same. In that regard, the learned counsel referred the decision of the Honorable High Court in Veena HS cited supra, in which it is held that person posted to a communicable distance and continued in the same city in one or the other post cannot complain that order is premature. In this regard, it is necessary to refer the decision rendered by the Honorable High Court in the case of R.D. Ramdas cited supra, wherein it is held similarly. Therefore, Your Lordship, the tribunal has taken this fact into consideration. Earlier, he was posted here. He was working as Assistant Commissioner of Tourism in Bangalore. Now he has posted. And again, Your Lordship, reposting it was given to him on 9/7/2024. It is again in Bangalore, BBMP Bangalore.
Where are you coming from? Where are you posted from?
I am coming from Mysore to Bangalore, Your Lordship. And another aspect, Your Lordship, the tribunal has not followed the same parameteria. It is incorrect. That is because in the Shobita case, I have only argued for respondent. Shobita was posted for only 4 months. Again, therefore, she was transferred. It is a premature on the face of it, Your Lordship. That because in that case, I have appeared for the respondent, I have lost it. The tribunal passed an order against me because Shobita has worked for only 4 months. She has been disturbed. Therefore, on the face of it, it's a premature transfer. That is my submission. Therefore, Your Lordship, tribunal has taken all these factors into consideration. Therefore, Your Lordship, it does not require any interference, Your Lordship.
Only thing which I wanted to point out, which I missed out, in the petition awareness which they have made in 20740, Lords may kindly permit me to read para 4, Lords. There's only 2 lines I need to read, Lords, where I indicated that he had requested the Honorable Minister. Just 4 lines above that he says, the government of Karnataka issued notification for acquisition of 5,000 acres of land for industrial area development around Chikbalapur and so on so district. By virtue of the acquisition notification in various states, the scheme of notification is under progress and not yet completed. Further, final notification is to be issued. It is very much necessary to conclude the notification. Having satisfied for the nature of the work of the petitioner, the recommendation they have sought to be made, saying that 5,000 acres is land which he is in charge of acquiring and things like that, where they've indicated why he wants to stay there. Only that I wanted to bring it to.
And ultimately, Your Lordship has said, why a government servant can he cling to a particular post? He has given from Bangalore into another place. That's how.
Grateful.
When you say that principle of prematurity, whatever is the, whether it is near or short, 6 months or 5 months or 9 months, the principle of prematurity in transfer is the same. It is the 2-year term is reduced. When it's in the council read one judgment where 2 years was completed and it was posted in Kolar and other. All these situations are different, but we did not tarry at the 5,000 acres issue also because the term that I have been given is about 1 year, 6 months, 4 months.
1 year, 9 months, Your Lordship. 3.5 months is short of
4 to
it.
5 months. Shobita was 9 months. Doesn't make a difference so long as the principle is the same. Please.
Yes.
Grateful.
Oblige for this.
Oblige, Your Lordship.
But interim order has to be extended.
Yes.
Oblige. That extension, otherwise evening you will come, Lord. Please.
Procedural matters. Number 11, Mallikarjun Reddy.
In the contempt petition, benefits have been given, my lords. I'll just place the same on record.
Has it been made subject to result of the writ petition?
No, my lords. Regard to the financial.
Demand. There is no
Being the
point.
situation, my lord, I do understand, my lord, but it's
This is
only
a
on the
two-page
principle,
compliance report for perusal of this honorable.
but it's only on matter of the principle, my lord.
Matter of principle in a better
Principle.
case.
As far as the tribunal's view, my lord, the approach wherein it has adopted the approach that of criminal appeal, my lord, as far as disciplinary inquiry is concerned, my lord, the approach should have been totally different. Wherein, my lord, at page number 19, it is
We'll
stated.
consider all that in a better case. Because here, in this matter, on question of principle, you cannot challenge something once the
They
state,
have implemented.
once it
my
is
lord.
implemented, then it cannot be further challenged by the Lokayuktha.
My lord, I do understand. Yes, my lord.
Just a moment. Nothing is reserved. Nothing is reserved.
Well, I
Two
have-
things, the financial benefits have been given, and they've also said that the application for compassionate appointment is being considered,
And
treating
rejected.
him to have died in harness.
My lord.
Such a case not in this case.
Very well, but
In
at least.
some other matter, this issue can be considered where it arises and where it is required to be considered, we can consider it. Well, the other question, whether independent of the government, you can maintain a writ petition against an order of punishment, that is also being considered. But here is a case where the government has given effect to the orders of the tribunal, after which will not lie.
I do
Definitely
understand,
will
my
not
lord, but on only a matter of principle, my lord, basically because taking into consideration the methodology adopted by the tribunal as far as the domestic inquiry is concerned, my lord, I'm only on that aspect.
The two
I
things
do
there.
understand, my lord, subsequent to the inquiry, the government has taken an action, penalty order has been passed, which ultimately, my lord, is the subject matter of the,
There also, there is another issue.
please, my lord.
Had been through the judgment of the tribunal also. The tribunal, if the tribunal had said that what was in evidence before the criminal
And-
court and the evidence before the inquiry are at variance, and therefore the finding in the inquiry cannot be accepted, I understand your contention. Here, that is not the case. Here, there is a trap mahazar. The trap mahazar is evidence before the inquiry,
Please.
not only before, there is
There
a,
as well.
there is a variation between what is found in the trap mahazar and the oral evidence of the witness. PW2, who is the shadow witness, says that
He was
He-
inside.
he was inside, he
Inside.
saw the money being handed over.
Yes,
The trap mahazar shows he did not go in.
yes.
That appears to be it is not as if it is what was said in the, I mean, the evidence in the trial has been taken into account. That is not so.
Please.
What has actually happened is there is a variance between the
has the contents and
documentary and the oral evidence.
Please.
Therefore, the documentary evidence has been taken note of. That is what has happened.
Please.
In that case, I don't think the wife and children have got.
True,
the
I do
benefits.
understand, my lord. It was only on that aspect, my lord.
Yes.
I do understand, my lord, as your lordship pointed out that it was a case of COVID death that being.
We've heard the learned counsel appearing for the appellant. It is
Petition.
for the petition. It is submitted by the learned counsel for the petitioner that the petition has been filed on a question of law with regard to the acceptance of the evidence in the inquiry. With regard to the examination made by the tribunal with regard to acceptance of the evidence led in the inquiry. However, we notice that the order of the tribunal has admittedly been given effect to by the government by paying all the benefits due to the family of the deceased government employee. It is submitted that the request made by the dependent of the deceased employee for compassionate appointment is also being considered. In the above factual situation, we are of the opinion that the writ petition filed by the Lokayukta raising a challenge against the orders of the tribunal, which already stands implemented at the hands of the government, may not be proper. The writ petition fails on that count and is accordingly dismissed. We make it clear that we have not considered any of the contentions raised in the writ petition.
Please. Obliged.
Sagar Bibi.
So appear for the petitioner's counsel. The government advocate took time to get instructions. Lord, you will also may kindly recollect that Lord, the petitioner is serving as a deputy secretary. As per Annex A1, Lord, page 27. I came to this post, Lord, on 10/1/2024. 10/1/2024, Lord. Annex A2, Lord, I have taken, Lord, charge on 10/1/2024 itself. Annex A2, CTC. Lord, now Annex A3, page 40, respond number 3 is placed in my place, Lord, by an order dated 23/7/2024. Lord, it is nothing but a premature transfer, that too without showing any posting to me. My respective submission is, as per the new latest transfer guidelines, the minimum period of stay is 2 years. And before completion of my period, Lord, I have been disturbed by posting respond number 3. Lord, even though, Lord, there are certain Clause 7, Lord, deals with the premature transfer also, Lord. I don't come under any of the categories. Lord, without completion of this minimum period of tenure, Lord, I can't be disturbed. That's why your lordship directed the other side to get instructions, Lord. I approached the Lord KAT. The KAT was as per Annex B, page 63. Lord, my interim prayer was not considered. Only notice was ordered, my Lord. Since there is a threat of, my Lord, my Lord, relieving me from the post in question, my Lord, I am seeking interim stay of Annex A3.
Counsel for the applicant urged that the applicant is disturbed prematurely from the present place of posting by the third respondent to the post of the applicant. Thereafter, another order is issued providing posting to the applicant.
No, another order is not issued, my lord. In fact, I don't know, my lord, why the KT has, in fact, another order is not issued, that's why, my lord, your lordship.
From the telephonic instructions, what I received is, my lords. The place where she is presently posted is the borrowing department. The parent category would be the DPAR. Earlier also, there were certain dissatisfactions expressed by the borrowing department with regard to the administration taken by the petitioners as such. Here also, the borrowing department had some reservations as such. So in the interest of the administration in the borrowing
The
department.
person who's now posted is from the borrowing department itself? Permanent cadre?
That aspect, I just missed the instructions.
If that is so, then it cannot be. If the person who's posted is from the same department, is from the borrowing department, then probably she cannot object. She cannot say it is premature also. But if that person is also,
I feel that they would not belong to the borrowing department, my lords. Usually parent category
Let
would
him
be
be, let him, you must be very, very clear. In fact, your lordship asked him the other side also. Last time asked, your lordship asked him whether any posting order is given, whether the tenure is
my
completed.
lords,
as a matter of fact, is the applicant, petitioner given any posting?
No, my lords. As of now also, she is working in the very same department. She's not been relieved is my instructions.
Till your lordship examines the status quo may kindly be.
Please
continued.
get instructions in the matter.
Hello?
Question is this.
Yesterday, I did not appear. I am appearing in vacuum. That's the only reason I'm not able to get full instructions.
I
My
understand.
apologies to the same.
What happens is this, a person by, be it deputation, be it transfer. If a person is to be moved out and another person is brought in his place, then this person who's moved out must be given some kind of a posting.
My lordships have
Because-
expressed the same before the AG also, my lords. We
Therefore,
will
what
take-
happens is
lords.
that in matters like this, even if the posting is to be, probably it is in the cadre of deputy secretary, it will be from one seat to another. In normal situations, this court, and they're well-paid employees in the senior cadre. In normal situations, there's no call for an interim order at all. You're forcing the hands of this court to grant interim orders because these persons are put in a limbo where there is no posting. So we are forced to pass orders so
lords.
that at least this person will have some kind of a posting.
Status
You
quo
don't
as on
just
today.
do it at one go. Post this person to another place. If there are reasons, state so, and bring the other person to the post without any of this issues arising. Yes.
Stay off next year, my lord,
But,
A3.
Government advocate seeks further time to get instructions list on Tuesday. In the meanwhile, if the petitioner is not relieved from the present place of posting, which is as deputy secretary.
Yes, deputy secretary.
Deputy
Inland,
secretary,
Deputy Secretary, Infrastructure Development, Ports and Inland Waterways Department, Ports, my lords.
got it? Did you get it?
Petitioner, petitioner,
Petitioner,
Yes.
below petitioner's details, it's been mentioned.
yes, deputy secretary, is,
At page, cost title, my lords, page
Yes.
5.
Infrastructure development.
serving as deputy secretary, infrastructure development, ports and inland waterways department, ports, Bangalore, Vidhan Sauda, Bangalore. The petitioner shall not be relieved till the next date of.
Week after next, my lords.
Yes,
Please,
then issue notice to the,
respond number 3 also, private parties.
respondent, notice has to go. Notice has to go to
Very much,
RP
my
also,
lord.
there is
Then in
time.
the usual
Yes.
course.
Please.
18, M. Nagaraj.
Transfer without posting.
What is the post?
Post is deputy, I work as deputy secretary.
Deputy secretary?
Deputy secretary, labor department, I was working.
Yes,
I
My
not even,
lords, 63 for a moment, my lords.
Page?
63,
63, my lords.
yes.
The last but one paragraph, my lords. In view of the said circumstances, the learned AGA is directed to get records and to file reply statement. And also directed the first respondent to provide posting to the applicant without loss of time within an outer limit of 1 week. my lords.
Therefore, I am before this court. Therefore, I am before this court.
So what should have happened is, she should have reported to DPAR, my lords. So after getting this order, she did not report to DPIR. Today, she is reported to DPIR as such. Is pending. To provide the copy to the.
Yesterday, my instruction, my lord, yesterday by 4 o'clock, the other person came and joined yesterday by 4 o'clock. So that without loss of time, he can that. Now, that is not the question, my lord. The question is
No,
that.
even the attendance is marked in the DPR. So they have to seek further directions from the tribunal to see that they get a posting from the date of reporting. That is as on today, my lords.
My lordship, your lordship, may consent to view, learner senior counsel has hitherto argued that whether an order of transfer without posting is sustainable under law. That is the question that. Now, they now cannot, by using a posting order, they cannot legalize an illegal order now at this stage. If the tribunal is running to administration to give the, saying that to give posting,
Matter is listed on 8/8/24.
I
listed there.
understand. I don't deny that.
Tribunal took the
My-
view
my
that it's a
submission-
curable defect and hence gave a outer limit of.
No,
one
it's not,
week is my respectful
it's
submission.
not a curable, one submission is that not, this honorable court categorically held that an order without posting is suffers from various infirmities. I produced annexure A2, my lord, that division bench judgment of this, justice referred by the learned senior counsel. Justice Jain Patel has held that para 6 place. Page number 40, page number 45, my lord. Para 6. May be permitted to read, my lord, please, that. Your lordship got it. Para 45. There are two serious infirmities in the transfer order. One is that when the petition is transferred to the post of assistant concerned forest, there is no clear posting order at a particular post of the petitioner. Unless the petition is lifted from the one place and posted at another place, it cannot be said that any vacancy has arisen of the petitioner, and such an exercise of the power cannot be appreciated, even if one keeps in mind that administrative circumstances for the public interest as the case may be. It is hardly required to be stated that when A is posted in place of B from one place to another place, then only there will be a vacancy of A, and B cannot be posted at the place of A. If A is lifted and his posting is kept in Lurch and B is posted to A, such a practice cannot be appreciated and deserves to be rather deprecated, and the reason being that the officer who is lifted from one place, not certain at which place he has to join the duty, and when he joins the duty at a different place. It cannot be said the vacancy in law has arisen at the original place. So long as the vacancy at the original place, the question of posting without is without any foundation. Hence, the transfer order cannot be said to be in the exercise, can be said to be in the exercise of legal modified. So therefore, my submission will that now by even a posting order is to be given also not that it is an illegal order as per the division bench judgment. By posting order cannot, by giving posting order that cannot legalize an illegal order. Therefore, my humble submission is that impugned order before the tribunal at annexure A1 requires to be stayed, please.
What would be the effect of the stay now? What would be the effect of the stay now? The other person has come and joined duty. The effect of the stay now would be.
I must continue. He must therefore I thought not that yesterday Matt, I approached the tribunal, then before I came that it was hospital. Yesterday after learning that he reported for duty. I don't deny that. For he had to go back his original place that he had to seek posting that.
Have you given posting to the, has the petitioner been?
Today, the attendance is marked, my lord. So from today, they are seeking 7 days accommodation to give the posting. Because the only reason.
It's not the proper.
I agree, my lords. That's
But now with the other person having come and joined, any interim order will also be.
Affecting the person who's.
Yes.
Now
I'm left, my lords, if we are able to find a solution on posting.
Lord, I'm left with not less than 1 year of service, 1 year of service. Let him go and seek let him that he came on promotion. He was not transferred. On promotion, he was given that. Your lordship kindly annexed the other person.
All that we can consider once he is here. This is the difficulty. He is not here. He'll come before the tribunal on 8th. And if the tribunal still does not consider this contention, and if the posting that you are given is also
No, now my humble submission is that whether the impugned order before the tribunal is that I have placed the division bench judgment of the tribunal, an order without posting is an illegal order, categorically held that. In spite of that, the tribunal without disregarding the orders of this honorable court, which has by these are discarded Article 141 completely. What does mean for doctrine of precedent? It is completely. On the other hand, discarding in that tribunal said that you posting that. Such an order can be maintained. That's all my humble submission. Therefore, my humble submission is order annexure A1 requires to be stated not that I don't deny the fact yesterday 4 o'clock he came and joined. Therefore, it may be said he let him go and join that.
yes,
seek posting.
listed on 9th.
My lord,
Tell us what happens in the meantime.
very much, my lord.
Yes, on 9th counsel. The other person has admittedly come and taken charge. He comes before the tribunal on the 8th. Let us see what happens. This on 9th. You want notice to be taken out, or he's already on notice before the tribunal for 8th. It is listed there on 8th. Do you want notice to be taken out here also?
I'll personally serve let me permit to. It might be not I personally serve ask the petitioner to go and serve on him.
Notice to the private respondent by emergent notice to the private respondent. In addition, the petitioner may also serve notice through the counsel appearing in the tribunal. Has he appeared? Has the private respondent appeared before the tribunal? He would not have.
Tomorrow he may appear tomorrow, but tomorrow, 60 is the date there before the tribunal. He may appear.
8th.
8th is ours. 8th is. And meanwhile, the petition may be permitted to serve the copy on the.
Yes.
$28.
Yes.
Lordships won't, I could not get any provision whereas there is a requisite for them to obtain prior permission for writing the examination. The only thing what I can point out and leave it at there would be page number 59, clause 3, my lords. ಹಿಂದಿನ ಸೇವೆಯನ್ನು ತಮ್ಮ ಹಕ್ಕು ಎಂದು ಪರಿಗಣಿಸುವಂತಿಲ್ಲ. Past service cannot be treated as your right is the line what's been written. my lords. That's the only thing what I could bring it out. my lords.
Your contention would be that is on 10/5/2007 and therefore the
Though permitted with a condition that past services cannot be claimed as a matter of right.
as a matter of right.
My lords, that's the translation of it.
In fact, I submitted that, my lords, by virtue of provisions, my lords, I get it.
And therefore you made the request. When was the request turned down?
My lords, it has not been done. What happened, my lords, the institution also wrote asking for, my lords, records to be summoned.
Yeah.
My lords, I waited, my lords, made the representation, nothing happened. Then I approached, my lords, the honorable tribunal, my lords, as even the latest representation which was my lords, submitted on 27/5/22 was not considered.
What does the tribunal say?
My lord, the tribunal says, my lords, that there is that I had tendered resignation and reported to duty. My lord, I said I did submit, but consideration is not there. And therefore, it says question of sending service records does not arise. Then they rely upon, they consider, my lord,
The dictum was person who has been granted permission is entitled. Person who resigns will not be entitled. That's the conclusive determination.
That may be wrong.
That's the reason I just brought it out to my lordships. At page 93, that's the dictum what follows. Because they had placed similarly placed persons, para 7 at 92 and 93, my lords. That was the determination and dictum laid down by the tribunal.
last
It is
93 last lines.
Clear that the government has not permitted the applicant either to appear for examination or for selection to the post of assistant teacher, Government Junior College. As admitted by the applicant herself, she has tendered her resignation as per law that was accepted by the authorities. Thereafter, she was relieved from duties. After leaving from duty, she had reported. So the provision has not been taken note of by the.
It was not discussed.
In fact, my lords, page number 93, last 3 lines. Starts with a mere submission of number of representation without acquiring any right under the provisions of law or by statute or by rules. This court cannot issue any writ of mandamus directing the response to consider the case of the applicant.
Was not the provision pleaded in the application?
My lords, it so happened, my lords, that was pleaded. Unfortunately, my lords,
Applicant couldn't appear, my lords.
my lords, on that day, when
Against
on the date of admission itself, my lord, the matter is considered, my lords, reserved.
page 87.
Oh, that is probably what happened, because it appears that it was pleaded.
It was, my lords, in the grounds, it was
Ground 6. For the learned counsel. For the petitioner as well as the learned counsel appearing, learned government advocate appearing for the respondents. It is submitted that the petitioner was initially appointed as assistant mistress grade 2 in the government higher primary school, government upgraded higher primary school, Shivamoga, in pursuance to order dated 23/4/2005. On 5/10/2006, she made a representation seeking permission to take back her testimonials and for permission to appear for examination pertaining to selection to the post of
High school teacher.
junior assistant
Tenth
teacher in
grade.
government junior college. Full stop. It is submitted that no reply was received. Though the petitioner had made a representation on 18/11/2006 requesting for permission to appear in the examination with regard to selection. The same was also not replied. Thereafter, the petitioner appeared in the examination and in pursuance to an order dated 24/4/2007, she was appointed as assistant teacher in the government junior college, high school wing at Kamasamudram KGF. Thereafter, a representation was made to the DPI, Deputy Director of Public Instruction,
Dated 10.
it is stated that even after